That important conversation, that critical exchange, like any other means, information and communication are vital to any major endeavor. They are needed to reach our destination safely. It is a designated calling, our solemn vow. The Science and Technology Information Institute of the Department of Science and Technology has 3.5 decades of making science and technology information work for the people. SNT are keys to achieving our purpose and vision. The business of information and communication is what really sets us apart from the rest. STII's 3.5 decades of handling information and communication work attributed to our values of integrity, excellence, commitment, innovation, and collaboration, more relevant today than ever, pursuing our dream to be the Science and Technology Information Authority in our DOST system. Milestones in the past millennium created the needed groundwork to get to where we are today. In the 90s, notable initiatives included the creation of the organizational and structural frameworks to set us going, the creation of ScINet Philippines in 1995. Then came the DOST fiber optic network backbone installed in 1996, followed by the establishment of the Regional Science Task Force, or RSITAF, and the DOST Media Core Group, or DMC, that paved the way for stronger partnerships ahead. While the frameworks are being established, equal attention was given to content. Several databases containing tens of thousands of documents that include abstracts, R&D projects, and a collection of profiles for S&T human resources and institutions were inspiring references. The first DOST communication plan was put to action with promotional strategies to create for publics a science culture. DOST's main news publication, the S&T Post, had increased circulation, reaching 10,000 copies per issue. At one time, an online version and its website, and soon to be a full digital magazine. It was also at this time when TV was tapped with a science segment over Itbulaga, and the campaign Make K and DOST was propagated. At the onset of the new millennium, STII learned how to accept the challenges of the times as a series of leadership changes occurred, taking the reins in OIC capacity. Our then Undersecretary Fortunato T. de la Peña, Assistant Secretary Carol M. Urobe, and Director Elizabeth A. Fontanilla took turns in managing STII's affairs before a full-fledged director was sworn in. Operations went on as usual and accomplishments were met, and in many instances exceeded set targets. This was also the time when STII participated in various committees and became a major player in the celebration of DOST's 50th anniversary, working closely with the Golden Jubilee Committee in coming up with promotional activities, comprising newspaper supplements, radio and TV broadcasts, showcasing 15 men and women of science, putting up exhibits, producing souvenir stamp, logo, and engaging our partners in the media to celebrate with us. Soon, STII was ready to further embrace change with a new mindset, guided by Einstein's philosophy that it would be foolish to do things over and over and yet expect to have different results. STII was able to tap new and creative modalities to fulfill its mandates and responsibilities, practically getting out of the box and exposing nasa siyensya ang pag-asa and science for everyone. Ignite the Mind was a jingle penned and sung by then STII head Raymond E. Liboro, and was even included as a regular part of the monthly flag raising ceremonies.
Is how we move the nation.
Not only a battle cry to a new perspective, but it was also the basis for STII's major strategies, like the Iba na ang Panahon program. This is an IEC-intensive initiation for communicating disaster risks and preparedness throughout the country, bringing together the local government units and the hazard science experts to speak one language. It was also during this time that STII passionately advocated the Philippine Standard Time that was decreed to be observed with a campaign to promote the Filipino time as to be always on time. Still giving close watch to disasters, preliminaries were underway for the creation of DOST-STII's STII Broadcast Initiative, which took flight in 2016 and soared high during the present administration, evolving from merely being a weather station to advocating science for the people. Starbucks also gained headway as it won the innovative International Library Project during the prestigious American Library Association at the ALA Annual Conference in San Francisco. The SWS survey was outsourced, and up-to-date media monitoring schemes were used to measure awareness level and media contributions to craft strategic communication initiatives that will create positive impact. At the present administration, new changes and challenges took place. STII was given a big budget that allowed elbow room for the implementation of institutional and even other support programs. DOST-TV evolved into a broadcast platform, exposing science for the people in TV via PTV4 and in radio via RP1 networks to promote major activities of DOST. Getting the nod of major award-giving bodies like the Gandigan Awards from UP Los Baños, as well as other industry recognitions. DOST-TV also bagged the Anak TV seal for child-safe, family-friendly program and has been included in the National Priority Plan of National Economic and Development Authority of NEDA for the past 4 years, the result of which earned recently tax-free donations to the Institute. Now, with more than 100 episodes of video features, documentaries, news programs in its archives, DOST-TV forged partnerships that further pushed in-house activities forward and upward to achieve DOST's development agenda. The biggest challenge is the present global crisis of an ongoing pandemic. While many activities were halted and many lives and income were also lost, STII remained firm and more determined to excel because STII cannot just be decimated. Moving on with caution, determined not only to survive but to thrive, to fly high and soar the sky, to not just be reactive but be proactive, perhaps bent over but resilient, exhausted yet exuberant, not staying victimized by circumstances but victorious despite the odds. In its 35 years, STII may have achieved a number of successes, but it will continue to be of relevant service in the coming years. And with God's grace and the passion and commitment to excellence of its people, the Institute is poised to gain more prominence and prestige for years to come. We fly high.
Bobcat 1-2, moderate to heavy precipitation, 12 o'clock, 20 miles, extends north 30 miles. Deviation 15 degrees left of course approved. Proceed when able.
Flight crew, please prepare for takeoff.
That important conversation, that critical exchange, like any other means, information and communication are vital to any major endeavor. They are needed to reach our destination safely. It is a designated calling, our solemn vow. The Science and Technology Information Institute of the Department of Science and Technology has 3.5 decades of making science and technology information work for the people. SNT are keys to achieving our purpose and vision. The business of information and communication is what really sets us apart from the rest. STII's 3.5 decades of handling information and communication work attributed to our values of integrity, excellence, commitment, innovation, and collaboration, more relevant today than ever, pursuing our dream to be the Science and Technology Information Authority in our DOST system. Milestones in the past millennium created the needed groundwork to get to where we are today. In the 90s, notable initiatives included the creation of the organizational and structural frameworks to set us going, the creation of ScINet Philippines in 1995. Then came the DOST fiber optic network backbone installed in 1996, followed by the establishment of the Regional Science Task Force, or RSITF, and the DOST Media Core Group, or DMC, that paved the way for stronger partnerships ahead. While the frameworks are being established, equal attention was given to content. Several databases containing tens of thousands of documents that include abstracts, R&D projects, and a collection of profiles for S&T human resources and institutions were inspiring references. The first DOST communication plan was put to action with promotional strategies to create for publics a science culture. DOST's main news publication, the S&T Post, had increased circulation, reaching 10,000 copies per issue. At one time, an online version and its website, and soon to be a full digital magazine. It was also at this time when TV was tapped with a science segment over Eat Bulaga, and the campaign Make K and DOST was propagated. At the onset of the new millennium, STII learned how to accept the challenges of the times as a series of leadership changes occurred, taking the reins in OIC capacity. Our then Undersecretary Fortunato T. de la Peña, Assistant Secretary Carol M. Urobe, and Director Elizabeth A. Fontanilla took turns in managing STII's affairs before a full-fledged director was sworn in. Operations went on as usual and accomplishments were met, and in many instances exceeded set targets. This was also the time when STII participated in various committees and became a major player in the celebration of DOST's 50th anniversary, working closely with the Golden Jubilee Committee in coming up with promotional activities, comprising newspaper supplements, radio and TV broadcasts, showcasing 15 men and women of science, putting up exhibits, producing souvenir stamp, logo, and engaging our partners in the media to celebrate with us. Soon, STII was ready to further embrace change with a new mindset, guided by Einstein's philosophy that it would be foolish to do things over and over and yet expect to have different results. STII was able to tap new and creative modalities to fulfill its mandates and responsibilities, practically getting out of the box and exposing nasa siyensya ang pag-asa and science for everyone. Ignite the Mind was a jingle penned and sung by then STII head Raymond E. Liboro, and was even included as a regular part of the monthly flag raising ceremonies.
is how we move the nation in this new.
Not only a battle cry to a new perspective, but it was also the basis for STII's major strategies, like the Iba na ang Panahon program. This is an IEC-intensive initiation for communicating disaster risks and preparedness throughout the country, bringing together the local government units and the hazard science experts to speak one language. It was also during this time that STII passionately advocated the Philippine Standard Time that was decreed to be observed, with a campaign to promote the Filipino time as to be always on time. Still giving close watch to disasters, preliminaries were underway for the creation of the DOST-STII's STII Broadcast Initiative, which took flight in 2016 and soared high during the present administration, evolving from merely being a weather station to advocating science for the people. Starbucks also gained headway as it won the innovative International Library Project during the prestigious American Library Association at the ALA Annual Conference in San Francisco. The SWS survey was outsourced, and up-to-date media monitoring schemes were used to measure awareness level and media contributions to craft strategic communication initiatives that will create positive impact. At the present administration, new changes and challenges took place. STII was given a big budget that allowed elbow room for the implementation of institutional and even other support programs. The US TV evolved into a broadcast platform, exposing science for the people in TV via PTV4 and in radio via RP1 networks to promote major activities of DOST, getting the nod of major award-giving bodies like the Gandigan Awards from UP Los Baños, as well as other industry recognitions. DOST
Yan, good morning, good morning, good morning, everyone. Let us all keep still for the singing of our Philippine National Anthem. Sir MJ? Ayan, while waiting for the Philippine National Anthem, may I request for those who have not yet renamed themselves, please rename yourselves. Okay. And let me see. Okay, so once again, let's keep still for the singing of the Philippine National Anthem.
Sa man
Now, let us put ourselves in the presence of God. Ayan. So once again, good morning, good morning, good morning, everyone. Ayan, and I would like to start this morning by saying this quote from Mick Hucknall. Sabi niya, copyright promotes artistic creativity and the free circulation of ideas. Ayan, that's why this morning, we will be having the webinar on copyright and intellectual property law. So first, I would like to acknowledge the presence of each and every one of us. Ayan, so igagallery ko muna para makita natin ang isa't isa. And if it is possible, kindly open your cam. Ayan. And ayan, para makita natin kung lahat ba tayo nakagamit ng virtual background. And in order for us to have a smooth flow of our program, may I ask everyone to try unmuting themselves. Just try to unmute. Huwag po muna kayo magsasalita para makita natin kung okay po yung, kung kaya po na mag-unmute. Ayan. So, okay. So, nakaka-unmute naman po tayo. Okay. Nice. Ayan, para po mamaya during our Q&A, pwede po tayo mag-raise hand and mag-unmute if we want to ask our question orally, or kung gusto natin, we can use later our chat box. Okay, so once again, thank you so much. And this morning, meron po tayong 52 participants. So, salamat po at pinaunlakan niyo po ang aming imbitasyon. I would like to acknowledge the presence of our director, Sir Richard, and our guest for today. Sir, good morning po. Ayan. And sa mga hindi pa po nakapag-rename ng kanilang mga sarili, ayan, once again, kindly rename yourselves. First po is your agency name to be followed by your personal name. Okay po? Ayan. Okay. So, I would like to introduce myself. Ayan, pero bago yan, saglit lang po. Ayan, so ano? Ayan, sige po. Okay, so I am Irene Alice Brillo. I am your moderator for today. Today, I work as Science Research Specialist 2 under the Information Resources and Analysis Division. And to start, to formally welcome everyone in this webinar, it is my pleasure to introduce to you our director for the Science and Technology Information Institute, Sir Richard Burgos. Good morning, Sir Richard.
Good morning. Can you hear me?
Ayan. Yes, sir. We can
All
hear
right.
you.
So finally, I can unmute myself. I am so hoarse today still, but it's nice to meet up with the members of the technical working group of DOST-STII Philippines. Magandang umaga sa inyong lahat. Ang tanong, kumusta na ba ang inyong barometer or misinformation, disinformation, fake news, and things like that? Puno na bang salo? We are so besieged by these things today, and that it can become irritating, if not immobilizing, in the things that we are supposed to do. Dapat nating labanan yan. And one of the tools in the arsenal made available to us in combating this is that we should capacitate ourselves. We should know, okay, one area which is copyright and intellectual property protection. Okay? So as librarians or information guardians at the DOST ScINet Philippines group, I think the public has the right to expect that all of us are aware of the legal protection in the Philippines for intellectual property. Okay? And that is why we are happy that we are joined by the Assistant Chief of the Accreditation and Standards Division, Bureau of Copyright and Related Rights of the Intellectual Property Office of the Philippines, Attorney Ezequiel de Guzman Valerio. Thank you, sir, for joining us today. Let's learn from him, and more especially, let's apply this knowledge and the things we do for DOST in the service of our people. Science for the people means also that we know exactly what we are doing in promoting it. All right. So in this short webinar, I hope you will find it useful, instructive, helpful for you in the conduct of your duties and responsibilities as information brokers for the public. Right? So sana maganda rin ang araw ninyo. It's a very bright day today. Don't forget to look out and enjoy the good weather that we're having today, and may that inspire you to continue to wear a smile all throughout the day. Because if you wear a smile, you not only tell yourself that it's okay to feel good, you also tell those who you interact with that it is okay to feel good, right? So with that, thank you at mabuhay kayong lahat.
And thank you so much, Sir Richard. So it's always nice to smile to start the day. Ayan, sabi nga ni Sir Richard, it's okay to feel okay. And, ayan. To start, to introduce to you or to us, para sa atin lahat. Our resource speaker for today, may I call on the Supervising Science Research Specialist of the Information Resources and Analysis Division. We have here with us Ms. Linderlit M. Maglake. Ma'am Linder?
Hello, good morning everyone. Ayan, good morning po. Isang magandang umaga po sa lahat. Good morning Sir Richard and good morning po sa ating mga TWG members ng ScINet and sa ating pong speaker for this day. So again, it is my pleasure po to introduce our resource speaker for our first webinar for this year. Una pa lang po ito, masusundan pa po ito. So who is going to discuss copyright and intellectual property law and help us craft our institutional policy. Ito po yung target natin, to create an institutional policy for the DOST-ScINet-Phil. Ayan. So our resource speaker for this day, Attorney Ezequiel de Jesus Valerio, is an attorney currently specializing in copyright law. He is a graduate of the San Beda College, Alabang School of Law. He is currently the Assistant Chief of the Accreditation and Standards Division of the Bureau of Copyright and Related Rights of the Intellectual Property Office of the Philippines. Before joining the IPO, he worked as a legal assistant for the Human Rights Victim Claims Board and a legal researcher for the Department of Agrarian Reform. Attorney Valerio is a lecturer with a gift for demystifying and simplifying the various concepts and issues on copyright. A person of keen judgment with a record for dependability and integrity. Ladies and gentlemen, please join me in welcoming our resource speaker, Attorney Ezequiel de Jesus Valerio. Good morning po, sir.
Hello, good morning, everyone. Thank you for that wonderful introduction. Thank you, Director Burgos, for having me this morning as your resource speaker on copyright law. Again, I am. You can just call me Attorney Chuck. Mas sanay ako sa nickname ko. Alam ko medyo malayo siya sa given name ko, but yeah, mas sanay ako Attorney Chuck. So for this morning, I will be talking I will be giving a briefer on copyright law as well as fair use. These are the important topics, especially for you guys na nasa library and information services, and also sa atin bilang mga kawani ng gobyerno. I will also discuss the special copyright rules for the government, diba? Meron kaming nirelease na implementing rules and regulations for copyright rules for the government a couple of years ago. So we will also discuss that later. Okay, so without further ado, I'll share my screen now. Okay, ayan. So this morning, we will be talking about copyright and fair use. Okay. This will be our outline for this morning. So first, we'll go over the basics of copyright law. Okay, ano ba tong copyright na ito at bakit natin siya pinag-uusapan? So we will go over the concept, and then we will discuss what are the rights that are included when you are an author na meron kang copyright, diba? So kasama dito yung economic rights mo and also yung moral rights. And then we will talk about gaano kahaba ang term of protection na binibigay ng batas for the copyrightable works. And then we will talk about the kinds of copyrightable works as well as those which are unprotected subject matter. These are the things na hindi siya covered ng copyright law. And kasama na dito, we will discuss, like I said kanina, the rules for government works. And finally, we will touch upon copyright infringement. Diba? Ito yung tinatawag na violation of copyright. And then from there, we will go to the next major topic, fair use. We will discuss what is this so-called principle of fair use and how can this help us sa ating trabaho bilang librarians and sharers of information. So we will discuss the concept of fair use, the relevant provisions in our intellectual property code na ma-apply natin regarding fair use, and then the 4 fair use factors, and I will give a sample fair use analysis na maaaring makatulong sa atin, diba? And then third major topic will be the best practices for libraries, and fourth, medyo pahapyaw ko lang di-discuss yung online copyright registration process namin sa IPO. Okay? So, sige, proceed na tayo. Okay, so part 1, it's all about the basics of copyright. Okay, so the concept and the rights involved. Okay, ano ba tong copyright na ito? Okay, bakit natin siya pinag-uusapan ngayong umaga? Okay, copyright, as you may well be aware of, it's one of the major intellectual property rights na pinoprotektahan ng ating intellectual property code. Okay. Kasama na dito, of course, I'm sure that you're all familiar, yung mga patents, di ba? Trademarks, trade names, utility models, industrial designs, etc. Okay, so ang copyright kasama doon sa mga major types of intellectual property that are protected by law. Okay? Ang coverage ng copyright ay it refers to the protection given to literary, artistic, scholarly, and scientific works. Okay, so copyright, it refers to a bundle of exclusive legal rights, diba? So take note, it's more than one right. Okay, it's a bundle of rights concerned with the protection of literary, artistic, scholarly, and scientific works. Okay, now so just to differentiate, diba, pag kinumpare mo siya sa, let's say, patent, a patent is concerned with the protection of an invention, di ba? Meanwhile, a trademark is concerned with the protection of a symbol or pwede rin siyang trade name that is used in business, di ba? So ang copyright naman, it's concerned with the protection of literary, artistic, scholarly, and scientific works. So mamaya makikita natin sobrang lawak ng saklaw ng copyright law. Okay? Kasi maraming kinds of works that can be covered. And also, just to clarify a quite common misconception, the policy objective of copyright law is not just to make the creators or authors earn from their works, diba? Although, yes, that is one of the goals of copyright law, but the ultimate objective is actually to balance the interests of rights holders with the rights of users of information. So, dapat merong balancing act, di ba? Na pinoprotektahan ang rights of the creators and our authors on the one hand, and on the other hand, pinoprotektahan din ang rights of the public to access the works that are being created, di ba? So hangga't maaari dapat it's a delicate balancing act. Okay? Next, we go to the categories of rights, di ba? What are the different rights that an author or a creator may exercise as a copyright owner? Okay, so there are two main classes of rights under copyright law. First, we have the economic rights. Ito yung pinaka familiar sa atin because these rights cover yung right ng author or ng creator of a work to allow or prohibit a third party from using or making copies of his work, diba? So kasama na dito, first, the right to control or to authorize or prohibit the reproduction of his work, diba? Or yung making copies of his work. Second, the right to transform or to adapt, diba? Adapt meaning to make adaptations or to make derivative works based on his work. Third, meron siyang karapatan na pahintulutan o pagbawalan ang pag-distribute ng kanyang gawa, di ba? Also, the right to display. So for example, a painter, meron siyang painting na nilikha. Meron siyang karapatan na pwede niyang pagbawalan ang pag-display ng kanyang painting, di ba, sa isang lugar. Panglima, the right of rental or the right to allow the rental of his work. Six, performance in public, the right to perform in public of a work. So for example, a composer, meron siyang nilikha na musical composition, di ba? So when the composition is being performed live, that counts as a public performance. So meron siyang karapatan na pagbawalan ito kung sakaling ayaw niya, di ba? And last, communicate to the public, di ba? So when, for For example, when an audiovisual work, so for example, a movie, diba? A movie is being streamed on Netflix, that counts as a communication to the public kasi you are showing the work to the public. So that's one of the economic rights na exclusive sa copyright owner. Okay? And then the next class, ito naman yung tinatawag natin na moral rights, di ba? Kasama na dito, of course, we all know na ang karapatan ng author or the copyright owner to be attributed as such, di ba? So, kung author ako ng isang libro, okay, karapatan ko na makilala bilang author ng libro na sinulat ko, di ba? Kasi parang it's very basic, di ba, na kung kakalat man yan, kung ibebenta man yan, kung i-distribute man yung libro na yan, dapat kilala ng mga tao na ako ang sumulat niyan, di ba? Also, one of the rights that I have as an author or as a creator is to make alterations to my own work, di ba? So, natural, gawa ko yan, so karapatan ko na baguhin yan, di ba? Kung gusto ko. Next, I have the right to object to any distortion of my work that will damage my reputation, di ba? So kung merong gustong gumamit ng gawa ko, pero meron siyang gustong gawing changes that I think will be prejudicial to my reputation, maaari ko siyang pagbawalan. Okay? And last, I also have the right to restrain the use of my name in attachment to a work na hindi ko naman ginawa, di ba? So kung merong third party na nagpapalabas to the public na meron akong ginawa na certain work na hindi naman pala sa akin talaga, so I can restrain the use of my name in connection with that work. Okay? Okay, so next question. When does a work obtain copyright protection? Kailan ba napoprotektahan ang isang literary or artistic work? Okay, in this regard, copyright is different from the other types of intellectual property like patent or like trademark. Kasi yung sa mga ganung types of works, kailangan muna silang irehistro sa amin sa IPO bago makamit ng kanilang creators yung protection of the law. Okay, so for example, kung ako inventor, kailangan ko munang mag-apply for a patent over my invention before I can prohibit others from using that work. Ang kinaiba ng copyright, okay, it is specifically provided both under our law and under international treaties na a copyrighted work is protected from the moment of creation. Okay? Section 172.2 of our IP code, nakasaad dito, works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as of their content, quality, and purpose. So, okay, from the moment that a work is created, matik niyan, meron ka ng copyright over it. Wala ka nang kailangang gawin na any prior registration with any entity or with any government agency before you have acquired copyright over your work. So, kung ako author, from the moment that I finish writing a book, meron akong copyright over it, di ba? Kung ako composer, the moment na matapos ko magkapag-compose ng isang bagong awitin, meron akong copyright over it, di ba? Kung ako painter, the moment I finish the painting, meron akong copyright over it. No need for prior registration, di ba? So yun ang kinaganda ng copyright, di ba? And this is something that most people are actually not aware of. Parang feeling nila, dapat yata i-register ko muna ang aking gawa sa IPO or sa National Library or with any other entity bago ako exercise ng aking karapatan bilang copyright owner. No, because the law states that your work is protected from the moment of creation. Okay? Ngayon, gaano naman katagal ang length of protection na binibigay ng batas? Okay? Because we have to remember, copyright is a statutory right, meaning lahat ng karapatan mo bilang copyright owner ay nanggagaling lamang sa binibigay ng batas. Okay? So, the law states that meron tayong general rule that protection lasts during the lifetime of the author plus 50 years after his or her death, diba? So ang general rule natin for most types of works, hanggat buhay si author or si creator nito, it is protected, okay? So during the lifetime of the author, and then pagkamatay niya, it's protected for another 50 years, diba? So kung makikita nyo, napakahaba ng length of protection ng copyright, diba? During the lifetime of the author, and then an additional 50 years after death. Except na lang for certain types of works which under the IP code merong sariling specific terms of protection. So for example, yung mga works of applied art, 25 years lang yan. Hindi siya lifetime plus 50. For photos, yung mga photographic works, di ba? So kasama na dito any and all kind of photos, whether taken by a camera or smartphone lang. Basta photographic works, 50 years from the publication if it was published or from the moment it was made if it was unpublished, 'di ba? So kung ikaw nagkuha ka ng picture sa smartphone mo, from the moment that you made it, it is already protected for 50 years, 'di ba? Counting from the date that you made it, 'di ba? And then for works of joint authorship, ito yung mga works na there are more than one author, 'di ba? So maaring more than one author contributed to a single work. Ang binibilang dito ay the life of the last surviving author and then plus 50 years, diba? So kung halimbawa, 3 kayong author na nag-contribute to a single work, nauna lang namatay yung 2 author, so hanggat buhay pa yung pangatlong author, nag-run pa rin yon, and then pag once namatay na siya, tsaka lang mag-start yung 50 years after death, okay? And then, lastly, for anonymous or pseudonymous works, ito yung mga works na either hindi kilala kung sino ang lumikha or kilala lang siya by a pseudonym or by a fictitious name. And also for audiovisual works, meaning any type of audiovisual work, whether shown on TV or on YouTube or on movies, diba, on cinemas, basta audiovisual work, 50 years also ang binibilang from the date of publication or the making. Okay? So now we go to what are the types of works that can be copyrighted. And under the IP code, we have a very long and very exhaustive enumeration of works that can be copyrighted. Of course, alam natin lahat, books, di ba? Pamphlets, articles, and other types of writings, they can be copyrighted. So kasama na dyan yung mga journals, kasama na yung mga thesis, mga dissertation, basta any types of writing, pasok dyan, okay? Next, periodicals and newspapers. And then yung mga lectures, yung mga sermons, dissertations prepared for oral delivery, whether or not reduced in writing or other material form, kasama yan sa pwedeng makopyright. Okay? Yung mga sulat, mga letters, mga liham, and then dramatic or dramatico-musical compositions, choreographic works, or entertainment in dumb shows. So kasama dito yung mga choreography for ballet, halimbawa. Diba? Yan. The choreographic work as a whole, it can be covered by copyright. Musical compositions, with or without words. So maaring kesyo may lyrics yan, kesyo walang lyrics, kesyo instrumental lang. It's covered by copyright. Original ornamental designs or models for articles of manufacture. Ito yung mga everyday objects na merong aesthetic value, na merong aesthetic addition in such a way na nagiging creative work of art siya. And then yung mga ating mga drawing, painting, architecture, sculpture, engraving, etc. These are also covered by copyright. Next, we have yung mga mapa, illustration, plans, sketches, charts, etc. relative to geography, topography, architecture, or science, di ba? So maraming types of scientific works that can be covered also by copyright. And then yung mga drawings of a scientific or technical character, di ba? Mga scientific and technical drawings and plastic works. Next, yan, yung mga photographic works, all kinds of photographic works, all types of audiovisual works and cinematographic works, yung mga pictorial, illustration, and advertisements, di ba? So kasama dyan yung mga parang mga pictorial drawing na lumalabas sa mga billboard halimbawa, or yan sa example ko sa screen, yung mga ganyang types of illustration, they are protected by copyright. And then computer programs, okay? So yung mga software and also yung mga, syempre kasama na rito yung mga mobile apps, 'di ba? Yung mga games, yung mga ganyan, yung underlying source code niya, the source code or the object code, they can be covered by copyright kasi it's a type of ano 'di ba? It's a type of writing, 'di ba? It's a type of language written down, 'di ba? So that can be covered by copyright. And yung ating catch-all provision for those that are not expressly included in the foregoing enumeration, yung other literary, scholarly, scientific, and artistic works, 'di ba? So as you can see, malawak ang saklaw ng copyright law, 'di ba? Almost any kind of artistic work that you can think of, maaari siyang covered by copyright. Okay? So, ngayon na nakita na natin kung ano yung mga works that are covered by copyright, ano naman yung mga types of tinatawag na derivative works, meaning that they are not original works because they are based on an existing work, but they are also covered by copyright. Okay? Kasi itong binanggit ko na enumeration na to, these are all original works, meaning originally created by their creators or authors, diba? But what about those types of works na they are based on an existing work, diba? So, or meaning they are derived from an existing work. Ito yung tinatawag na derivative works, diba? And I'm sure we are all familiar with yung mga dramatization, translation, adaptation, abridgment, arrangement, and other alterations, diba? So, pinaka-common example, as you can see from the movie posters, yung mga movies that are based on books, diba? So, in this type of scenario, merong book, diba? So, the book has an existing copyright. And then, here comes a movie studio planning to create a movie based on the book, diba? So, in this case, yung movie that will be created that is based on the book will be entitled to a separate and distinct copyright protection as compared to the book, diba? So, magkahiwalay sila ng copyright even though the movie is based on the book, meaning pareho sila ng contents, diba? Pareho sila ng characters, pareho ng plot. But since magkaiba sila ng medium, diba? The movie is entitled to a separate copyright because it is considered a derivative work. Okay, so that's the principle governing derivative works. Okay, so aside from the adaptations, nandiyan din yung mga collections of literary, scholarly, or artistic works, diba? And also compilations of data and other materials which are original by reason of the selection or coordination or arrangement of their contents. So, ang perfect example dito is, for example, merong publisher na naglabas siya ng compilation of short stories, diba? Kuyari, Best Philippine Short Stories of 2021. Halimbawa, ganun yung title, diba? So, in that sense, it's a collection of short stories, diba? It's a compilation. So, each individual short story na nakapaloob sa libro na yun, may kanya-kanyang copyright yan, diba? Kasi magkakaibang authors yan eh. However, by arranging the short stories in its own compilation, so malamang ang gagawin ni publisher dyan, of course, meron siyang sariling book cover, maglalagay siya ng bagong introduction, pwede siya maglagay ng forward, ng afterword, pwede siya maglagay ng mga introduction to each short story, pwede maglagay ng gano'n, di ba? So in that sense, by all those additions, nagiging original yung pagka-compile niya. So in that sense, it becomes a derivative work that is entitled to a separate copyright from the original short stories na nakapaloob dito. Okay? So yun yung concept behind the derivative works called compilations and collections. Okay, so now that we discussed kung ano yung mga works that are covered by copyright, ano-ano naman yung mga ang tinatawag ng batas ay unprotected subject matter, meaning these are the works that are not covered by copyright. Okay? Unang-una dito, and most important, a mere idea. Okay? if someone has a mere idea, but he has not yet expressed it in any tangible form. So halimbawa, nasa isip pa lang niya, pero wala pa siyang isusulat, wala pa siyang nalilikha, na kahit ano, basta nasa isip lang niya, he or she cannot later on claim na pag merong nakakopya ng idea niya and nakagawa ng bagay, expressing that idea, hindi niya pwedeng sabihin na, oh, ninakaw mo yung idea ko. No, because that idea in itself is not yet protected by copyright. Why? Because you have not yet expressed it in any physical or tangible form. Diba? So it's very important to be aware na a mere idea, diba? A mere idea in your head is not yet protected by copyright. Diba? Wala ka pang pag-aari dito. Diba? Kahit ikaw lang ang nakaisip dito, pag mayroong ibang nauna at nakagawa, diba? At ikaw wala ka pang nagagawa, you cannot claim na there is copyright infringement. Next, we have here yung procedure, system, method of operation, a concept or principles or discoveries, or near data as such, diba? So itong mga bagay na to, kaya siya hindi protected by copyright because the law wants that these should be disseminated as widely as possible with the fewest hindrances, kumbaga, diba? So kung kunyari, merong isang tao na nakaisip ng bagong scientific principle, diba? Or bagong scientific discovery, diba? Or isang concept na, kunyari, or merong nakaisip ng isang bagong method of accounting, halimbawa. That method or that concept or that principle itself is not covered by copyright, okay? Even if isulat mo siya, kasi diba, kanina sabi natin, a mere idea, it's not covered by copyright unless i-express mo into something tangible, diba? So in this case, the principle, even if i-express mo siya, even if nasulat mo na siya, hindi pa rin covered yung underlying principle na yon, diba? However, may konting nuance dito. If you write, for example, a book explaining or diba, parang expounding on your concept, that can be covered by copyright as a literary work, diba? However, the coverage will only extend to your explanation or to your expounding of the concept, but it will not cover yung mismong concept or principle itself. Okay? I hope that's clear, diba? Kasi nga, the law does not want any one person to have a monopoly over something that should be used by everyone. Diba? Yun yung underlying principle dito kung ba't siya hindi protected. Diba? And then we have yung mga news of the day and other facts having the character of mere items of press information. So basically, yung mga binabalita, diba? Yung mga binabalita na factual incidents, diba? They are not the facts themselves, they are not copyrighted, diba? Of course, the way that you report them, it can be covered by copyright, diba? So a news article reporting on a certain fact, it can be covered by copyright, diba? Kasi merong creativity involved in the writing of the article. But the underlying fact being reported, that is not covered by copyright. Kasi otherwise, diba, it would lead to a situation wherein pag merong isang reporter na nauna siyang makapag-report sa isang fact na nangyari, wala na ibang pwede makapag-report, diba? Kasi may copyright na siya. So, that's absurd, diba? So, kahit sino pwede makapag-report describing a single incident or a factual incident. Kanya-kanyang reporting yan, kanya-kanyang creative yan, creativity in reporting. So, that is protected by copyright. But the underlying news being reported, it's not covered. Next, we have here yung any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. So yung mga, for example dito, yung mga decisions ng Supreme Court na nilalabas, yung mga memorandum circular na nilalabas ng mga government agencies, yung mga ganyan, these are not protected by copyright. And then, last, and this is something that we will go into detail in the succeeding slides. Okay? works of the government, meaning works done by government employees pursuant to their regularly prescribed official duties. These are not protected by copyright. Okay? And to clarify this exemption further, kami sa bureau namin, we released a set of implementing rules a couple of years back, expounding on the copyright rules for the government, diba? So these rules are contained in the ScINet-Phil Memorandum Circular 2020-024. So let us discuss this a little bit lang kasi very important to us, diba? Tayo bilang mga kawani ng gobyerno, we must be aware kung ano yung mga works natin that are not covered by copyright, as well as kung ano yung mga pwedeng ma-cover, di ba? So, of course, we have here a few important definitions, di ba? So, government refers to those offices within the scope of the civil service, di ba? So, covered dyan lahat ng branches sa legislative, executive, and judicial, lahat ng mga instrumentalities and agencies of the government, kasama na yung mga GOCC, yung armed forces, di ba? Yung mga independent constitutional commissions natin like the Civil Service, COMELEC, COA, and kasama dito yung mga state universities and colleges and local community colleges. These are all considered as part of the government, diba? Part of the national government ng Pilipinas. And then, who are those that are considered as an officer of the government, okay? So, again, it refers to a person holding office in the Philippine government, either career or non-career service, by direct provision of law, popular election, or appointment by a competent authority. So, kasama na dyan yung mga permanent, temporary, substitute, coterminous, fixed term, contractual, or casual. Basically, it is synonymous to the term government employee. Diba? So, lahat tayo dito, or majority sa atin dito, I'm sure, considered as government employees, di ba? Now, what is a work of the government, di ba? A work of the government, with respect to copyright law, is a work created by an officer or employee of the Philippine government or any of its subdivisions, instrumentalities, including GOCCs, as a part of the officer or employee's regularly prescribed official duties. Okay? So the next definition that is important is ano ba yung tinatawag na regularly prescribed official duties, diba? So these refer to the duties and responsibilities stated in an employee's or officer's Civil Service Commission Memorandum Circular Form number 1 or yung tinatawag na position description form, diba? Including yung mga functions na related, diba? So lahat naman tayo, meron tayong tinatawag na position description form, nakasaad dito kung ano yung mga dapat na trabaho na ginagawa natin sa ating position in the government, di ba? So kasama na dito lahat ng related functions, di ba? So basically, anything that a government employee does that is prescribed by his official duties as stated in the form, these are considered as work of the government. Okay? So, kung ganon, we now go to the general rule, and this is expressly stated in our IP code. Okay? Nakalagay that no copyright, take note, no copyright shall subsist in any work of the government created by an officer or employee thereof as a part of his or her regularly prescribed official duties. So, the general rule is yung ating mga gawa bilang mga kawani ng gobyerno, yung ating mga ginagawa, yung ating mga output, yung ating mga sinusulat, kung ito ay parte ng ating trabaho bilang kawani ng gobyerno, wala tayong copyright over it. Okay? Walang copyright tayo bilang the employee, walang copyright yung ating agency, walang copyright yung ating bureau, or walang copyright yung kahit sino man. Kasi nga, it's considered a government work. Okay? So that is the general rule. I hope that is clear. Of course, meron tayong exceptions, and these are first, works that are not part of his or her regularly prescribed official duties. So for example, ako, okay, isa akong attorney para sa IPO, pero on the side, meron akong hobby, let's say, photographer. So I take photos of random things on the side. Obviously, yung pagkuha ko ng photos na yon, hindi siya part ng trabaho ko bilang attorney sa IPO, di ba? So in that sense, yung mga photos na kinukuha ko na yon, since they are not part of my official duties as an IPO employee, I have copyright over my photographs. Okay? That's the simple explanation, di ba? So that this serves to delineate kung ano yung mga ginagawa natin as part ng ating trabaho versus yung hindi naman parte, di ba? So yung pag parte ng trabaho natin siya, klaro, under the law and under our circular, wala siyang copyright. However, if you do something that is not part of your regularly prescribed official duties and it is a literary or artistic work, then yes, you have copyright over it. Okay? The second exception is works made for the government by an author who is not a government employee. Diba? So for example, consultant. Diba? I'm sure that we are all aware naman na every once in a while, may mga agencies na nag-hire ng consultants. Diba? So these consultants, based on existing civil service law and circulars, hindi naman sila considered as government employee, diba? So yung mga ginagawa nila, they are not part of their regularly prescribed official duties, diba? So maaring yung mga gawa nila ay covered by copyright, okay? Excuse me. Okay, so third dito, works that are covered by the Technology Transfer Act. Okay, so the TTA, it's a separate law that covers certain situations wherein, for example, may mga research that are funded by an external by a government funding entity, and yung research na ito na output ng mga researchers ay pwedeng magkaroon ng copyright over it. But of course, these are related to very specific and certain instances only. Okay, but the general rule still remains that for works that are part of the duties ng isang empleyado ng gobyerno, walang copyright over it. Okay? However, the IP code also states that hindi naman porket walang copyright ang isang employee or isang agency over the work of its employee, hindi naman ibig sabihin na wala na siyang magagawa over it, na kahit sino na lang pwedeng gumamit ng kanyang gawa. Okay? Under the IP code, there's a provision that states na while the government does not own the copyright to a work of any of its employees na ginawa yun according to their duties, it is actually not precluded from exercising proprietary rights over the work against any party. Anong ibig sabihin nito? Lalo na if, for example, a third party wants to use a government work for profit. Let's say meron siyang gustong gamitin na copies ng isang agency circular. Gusto niya itong i-compile, let's say, into a book, and then gusto niyang ibenta. So in that sense, even if walang copyright si agency over the circular kasi nga government work siya, it can still exercise proprietary rights over it. Meaning, lalo na pag sa ganung example na for profit yung gagawin ng third party, kailangan pa rin niya magpaalam from the agency, and the agency can actually prohibit the use, 'di ba? Kung if it deems it necessary, pwede niyang hindi payagan yung paggamit nito, 'di ba? So yun yung tinatawag na proprietary rights, 'di ba? As an owner, you can still you still have a say on whether or not papagamit mo yung gawa mo, 'di ba? Even if technically wala kang copyright over it. Okay? So in our circular, we discussed further ano yung mga rules that will govern the use and exploitation of government works. So, any natural or juridical person, association, entity, or institution may use and exploit the works of the Philippine government. That's the general rule. Okay? Provided that prior approval is obtained in the following instances, diba? So, the general rule, pwedeng gamitin ang work ng isang isang agency nang walang paalam kasi nga walang copyright. However, prior approval is necessary in the following instances. So first, from the government agency or office wherein the work is created for the exploitation of such work for profit, diba? So ito yung sinasabi ko kanina sa example ko, kung merong gustong gamitin yung work ng isang ahensya for profit, kailangan niya magpaalam dun sa concerned government agency. And actually, that agency or office may impose as a condition for the use of the work, the payment of reasonable fees that are akin to royalties, diba? Kasi nga, yung royalties, ito yung binabayad for the use of a copyrighted work. But since the work in this case is a government work, so wala siyang copyright, pwede pa rin maningil si agency ng reasonable fees na parang in a way, it's akin to royalties but not technically termed royalties, diba? Parang minimal fee lang siya for the use of the work if it will be used for profit by a third party. Okay? And then second, kailangan magpaalam from both the government agency and the private author in case of works of joint authorship, diba? So for example, if a work is jointly authored by an agency and a private party, a private person, diba? So dahil ganun yung situation, si private person, meron siyang copyright, diba? Kasi nga, hindi naman siya government employee. So, kung gagamitin yung work for profit, dapat magpaalam sa kanya. Okay? And also sa agency. Next, we have here, kailangan magpaalam from the government agency if it is a transferee of copyright. Diba? Kasi, one of the things that are allowed under our IP code is ang government agency, okay, it's clear na wala siyang copyright over the works of its employees. However, it can be an owner of copyright if merong third party who is a private person or private copyright owner na ililipat yung copyright sa kanya. So, okay, take note, while an agency does not have copyright over the works of its own employees, it can nevertheless be a copyright owner if someone else transfers their copyright to them, diba? Kasi ang copyright, it's a private right, diba? So, it's just like any other property na pwedeng ilipat ng copyright owner yung ownership to another person or entity, diba? So, in that case, pag dilipat yung copyright sa agency, then it becomes the copyright owner, okay? By virtue of that assignment. So kung ganon, kung ang gagamitin na work ay isang work na inilipat lang sa inilipat lang sa agency, in that case kailangan magpaalam. And last, yung mga authors ng mga speech, lectures, sermons, addresses, etc. na binasa sa courts of justice or before admin agencies and in meetings of public character, kailangan magpaalam if gagamitin ito for the purpose of making a collection, diba? So kung magko-compile ng mga speeches halimbawa ng isang agency head, diba? Kung magko-compile ng mga addresses given by the president halimbawa. So pag ganon, kailangan magpaalam. Okay? Next, paano naman kung ang government agency ay user ng copyright works, diba? So paano, in this case, si agency ang may balak gumamit ng mga copyright works. So what are the rules, diba? The government may be a user of works belonging to other agencies entities and individuals, both public and private. Okay, so klaro yan. The government needs to seek permission first from the copyright owner or assignee if the work sought to be used is a copyright work. So that's the general rule, although later on, makikita natin na there are certain instances under fair use na the government can use a copyrighted work even without seeking permission. Okay, so yung naka-outline dito, ito lang ang general rule of na kailangan magpaalam ng agency sa copyright owner pag meron siyang gagamitin ng work. Next, the agency also needs to seek permission before using the work of another agency, di ba? Even if such work is a government work and therefore walang copyright, di ba? Kasi ano lang, parang basic common courtesy, di ba? Bago mo gamitin yung gawa ng isang ahensya, paalam ka lang, di ba? Basic courtesy lang. And also, ito ang sinasabi ko, use by the government may be considered as fair use, as statutory fair use, if the use is imbued with public interest and compatible with fair use. So mamaya sa discussion natin on fair use, doon natin malalaman when is it allowable for an agency to use a work even without seeking permission from the copyright owner, diba? And even without paying royalties. And as a reminder lang, the moral rights of the authors should always be respected. So even if ang paggamit ng government agency ay according to fair use, so meaning hindi na kailangan magpaalam, it's still always advisable to give attribution, to give proper attribution to the author kasi nga kasama to sa moral rights ng author, di ba? Na makilala bilang yung author ng kanyang gawa. And ito yung sinasabi ko kanina na the government is not precluded from receiving and holding copyright that is transferred to it. So pwede siya maging assignee ng copyright from a private person. So in that sense, the government agency becomes a copyright owner. And last, we go to copyright infringement, diba? So ito yung tinatawag na violation of the author's copyright, diba? So kailan to nangyayari? It occurs when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. So basically, ang paggamit ng isang copyrighted work nang walang pahintulot or nang walang paalam from the copyright owner, the general rule is it will make you liable for copyright infringement, diba? So merong karampatang civil, criminal, and administrative penalties yan, diba? Kung sakaling you are found guilty of committing infringement. And also take note, lack of intent to commit infringement or yung tinatawag natin na good faith, it's immaterial if you are committing direct infringement. Kasi nga, malum prohibitum, di ba? May tinatawag sa criminal law na malum prohibitum, meaning na kahit wala kang intention to commit it, it's considered as it's not a valid defense that will make you that will absolve you from infringement, di ba? And just a reminder lang, copyright infringement is not the same as plagiarism. Okay? Kasi sa infringement, gumamit ka ng walang paalam, di ba? Sa plagiarism naman, maaring nagpaalam ka, di ba? Pero doon sa paggamit mo, inappropriate mo yung work. Meaning, pinalabas mo na ikaw mismo ang nagsulat doon. Halimbawa, instead of giving attribution to the author, pinalabas mo na gawa mo siya. Diba? So, nagkakaroon ng misappropriation of somebody else's work. That's the very gist of plagiarism. Diba? So, magkaiba yung concept. Although, there are times na meron siyang overlap, magkaiba ang infringement at plagiarism. Okay? So, sige, we can proceed to the next part of the lecture. Fair use, di ba? What is this concept of fair use? Under copyright law, di ba kanina na discuss natin, the general rule is whenever somebody wants to use the copyrighted work of another, kailangan niya magpaalam, diba? It's very basic. Since hindi ikaw ang gumawa nun, kung gusto mong gamitin yung gawa ng iba, magpaalam ka muna, diba? Very basic. However, the law recognizes that obtaining permission before the use of a work is not always practicable in all instances, diba? So there may be times na hindi practical na magpaalam muna, diba? So in those cases, the law says na walang infringement, diba? If you will do something or if you will use a work in such a way na pasok siya under one of the uses na tinatawag na fair use, it means even if hindi ka nagpaalam, even if hindi ka nagbayad ng royalties, you are not liable for infringement, diba? So this fair use, it's a copyright principle based on the belief that the public is entitled to freely use portions of copyrighted materials for certain purposes imbued with public interest. Okay? Generally, it refers to any copying of copyrighted material done for a limited and transformative purpose, such as to comment upon, criticize, or parody a copyrighted work. And also, it allows the use of a work without permission from the copyright owner, and there's no need to pay royalties. Okay, so I hope that's clear. Next, ang fair use, it's a defense against a claim for copyright infringement. So take note, dahil siya ay defense, it can only be properly raised pag nagkaroon na ng complaint against you for copyright infringement, diba? Pero later on, we will see na even if wala pang complaint, you can actually make your own determination on whether or not your use can be considered as fair, and this will help you make decisions in your everyday lives na hindi mo na kailangan, kumbaga parang huwag kang matakot na makasuhan ka ng infringement kasi nga if you will make your analysis of the fair use factors, which I will discuss later on, magiging kampante ka na itong ginagawa ko nito ay safe to, even if hindi ako nagpaalam and even if hindi ako nagbabayad ng royalties. Okay? So it's a defense against infringement. Of course, the inherent risk is ang final determination of whether or not a use is indeed fair use can only be made by a court of law, di ba? So dahil nga defense siya in a formal complaint, pwede mo lang siyang erase pag meron ng kaso before a court. And take note, only a court of law can make a final determination on whether or not something is fair use. So kami sa IPO, sa Bureau of Copyright, we cannot say na, ang ginagawa nyo na yan ay fair use. Ito hindi fair use yan. Because, minsan we get inquiries saying na, meron kaming binabalak gamitin na books, ganyan-ganyan. Sasabihin yung scenario and then ang question nila is this fair use or makakasuhan ba kami for infringement? Our bureau, unfortunately, cannot answer that, yung mga ganong types of questions. Why? Because we are not a court of law, diba? Only a court of law can say whether or not fair use yan or whether or not infringement yan. In cases of administrative infringement, ang merong jurisdiction sa IPO ay not the Bureau of Copyright but our Bureau of Legal Affairs, diba? So sila yung nagde-decide ng cases, ng admin cases for infringement, diba? So kami, we cannot answer yung mga consultations na ito ho ba magiging liable ba kami for infringement or ito ho ba fair use to? Unfortunately, we don't have the authority to answer those kinds of questions. Next, it's decided on a case-to-case basis, and because of that, there are no fixed rules pagdating sa fair use because it's actually meant to be flexible. And this very flexibility is actually beneficial for us, di ba? Yung mga potential users, because it kumbaga parang hindi niya kinakahon yung concept ng fair use. Kasi ang danger dito pag naglabas ng mga strict guidelines to be followed, 'di ba? Yung mga talagang inflexible numbers to be followed. Ang danger is, what if hindi na siya applicable in the future, 'di ba? So ang magiging effect niya, pag hindi na siya applicable, so pag lagi na lang na-violate yung ano na yon, yung standard na yon, nagkakaroon lagi ng infringement, 'di ba? And we don't want that to happen. We don't want users to be afraid of copyright law to the extent na hindi na sila makakapag-disseminate ng information, 'di ba, to the public. That defeats the very purpose of the ultimate balancing of interest ng copyright law, 'di ba? So now we go to the relevant provisions in our intellectual property code sa fair use, 'di ba? Lalo na ito yung mga relevant sa inyo bilang DOST-STII, 'di ba? At saka to us government employees in general, 'di ba? So under section 184.1 nakalagay dito, the following acts shall not constitute infringement of copyright. Letter H, the use made of a work by or under the control of the national government or by the National Library or by educational, scientific, or professional institutions where such use is in the public interest and compatible with fair use. So itong specific provision na ito, it basically states na pag gobyerno ang gumamit ng isang copyrighted work, okay? Or pag ang gumagamit dito ay National Library or ang gumagamit ay isang educational or scientific or professional institution at ang gamit ay imbued with public interest and compatible with fair use, the government or the library or the institution is not liable for infringement, even if they did not seek prior permission from the copyright owner or even if hindi sila nagbabayad ng royalties. Okay? So, this is actually, tayo bilang government employees, dito tayo pwede mag-rely, okay, sa paggamit ng mga copyrighted works, even if without seeking permission, as long as, huwag natin kalimutan, the use is in the public interest and is compatible with fair use. So, mamaya i-discuss ko how can it be compatible with fair use. Meron tayo diyang 4 factors na ine-evaluate. And also, sa letter L naman, the reproduction or distribution of published articles or materials in a specialized format exclusively for the use of the blind, visually and reading impaired persons, provided that such copies and distribution shall be made on a non-profit basis and shall indicate the copyright owner and the date of the original publication. Okay, so dito sinasabi na, kasi diba, kung maalala nyo kanina, diba, one of the exclusive rights ng copyright owner ay yung right of reproduction. So pwede niyang pagbawalan or payagan yung pag-reproduce or paggawa ng copies ng kanyang work, diba? But in this case, if yung pag-reproduce or yung pag-distribute ng kanyang work ay for a specialized format, exclusively for the visually impaired, pwede siyang gawin ng walang paalam. So, ang perfect example dito is, for example, converting a book from the regular format into Braille, di ba? So, Braille, so para madali siyang mabasa ng mga blind and visually impaired. So, in that case, yung conversion na yon or yung pag-adapt ng libro and paggawa ng copies ng Braille copies ng book, pwedeng gawin even without permission from the copyright owner. Okay, so take note, in relation to this, meron din tayong tinatawag na the Marrakesh Treaty. This was a treaty that the Philippines acceded to a few years back. And as a matter of fact, naglabas na rin kami sa IPO. Naglabas na rin kami ng accompanying implementing rules para dito sa Marrakesh Treaty, this deals specifically with this provision, yung paggawa ng mga accessible works for the visually impaired, di ba? So you can consult that if you have questions on how to reproduce or distribute copies for the blind and visually impaired. And then under section 185 naman, ito yung tinatawag na general fair use provision ng ating IP code. Okay, so nakalagay dito, the fair use of a copyrighted work for criticism, comment, news reporting, teaching, including a limited number of copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright, diba? So parang ito yung pinaka-umbrella provision natin, diba? So whenever the use of a work is for the purpose of criticism, comment, news reporting, teaching, okay? Teaching including the making of a limited number of copies for classroom use, scholarship, research, and other similar purposes, hindi siya infringement, diba? Okay, so very clear yan. And this is kumbaga ito yung pinaka-mother provision natin on fair use under the IP code. So pag for example, nag-photocopy ako ng materials at gagamitin ko siya for classroom use, di ba? If I make a limited number of photocopies for classroom use, normally kasi, di ba, like I said kanina, the reproduction of a work, general rule, kailangan ng paalam ng copyright owner. But in this case, if I make a limited number of copies, nagpa-xerox ako, nagpa-photocopy ako ng limited number of copies, for teaching or for classroom use, di ba? Or for personal use for research, it is not infringement of copyright, di ba? So it's allowed by law. Next, section 187. This section deals with the reproduction of a published work. Okay? So in this section, a natural person may reproduce a published work in a single copy exclusively for research and private study. Diba? So, klaro yun. Diba? Kung merong isang tao na gustong magpa-photocopy, halimbawa, ng isang published work, isang copy lang exclusively for his own personal use, para sa kanyang research and private study, it's allowed by law. Okay? However, what is not allowed is the reproduction of a work of architecture, okay? Or, hindi rin pwede yung reproducing an entire book, di ba? Or a substantial portion thereof, or of a musical work in graphic form. So, ito yung naalala ko nung nasa law school ako, di ba? Usong-uso yun yung tinatawag na book alike, di ba? Kasi ang mahal ng ang mahal ng law books, di ba? Usually, lalo na yung mga sobrang kakapal, minsan umaabot ng mahigit 2,000 yan for just one book. So, naalala ko, uso-uso yung book alike, 'di ba? Wherein yung buong libro ipapa-photocopy, 'di ba? Para makatipid ka. And kaya siya tinatawag na book alike, 'di ba? Kasi nga pwedeng gayahin talaga pati yung mismong cover, 'di ba? Yung hardbound pa siya na talagang ang ganda ng pagkakagawa, 'di ba? Kopyang-kopya. Hindi pala pwedeng ganoon, 'di ba? So parang kumbaga back then when I was still a student, hindi pa ako aware about copyright laws, di ba? So, pwede, kung ako a single person, I can make photocopies of a work for research, for my own personal study, pero hindi ko pwedeng pa-photocopy yung buong libro. Okay? So, it's expressly stated na an entire book cannot be reproduced. Di ba? At yung substantial portion thereof. No? In this case, wala tayong sinusunod na specific number on what constitutes a substantial portion, di ba? So ito yung tinatawag ko kanina na yung flexibility of fair use, di ba? The flexibility of copyright law, yung whether or not a portion is substantial is only up for a court of law to decide, di ba? So I cannot say na, for example, pag lumagpas ng 50% ng pagkalahati ng libro, pag lumagpas ng kalahati ng libro, ang pina-photocopy mo, infringement na yan. Unfortunately, we don't have those kinds of exact figures, diba? Kasi nga, the law is meant to be flexible. Next, yung mga compilation of data and other materials. Yan, yung mga hindi pwedeng i-reproduce yan. Also, a computer program, di ba? Hindi siya pwedeng i-reproduce except only when allowed by law. So there are only certain instances wherein pwede ka maggawa ng kopya ng computer program. And hindi pwede mag-reproduce ng any work if the result of such reproduction would unreasonably conflict with the normal exploitation ng work or would otherwise unreasonably prejudice the legitimate interests of the author. So basically, ang sinasabi lang dito ay we have to be conscious na dapat yung paggawa natin ng copies of a work, diba? Yung pagpapa-photocopy natin or halimbawa, gano'n, it's done in such a way na hindi naman naapektuhan yung right ng author to earn from original copies ng kanyang gawa, di ba? So dapat let's be conscientious lang na dapat wag sobra-sobra yung paggawa natin ng copies, okay? Next, ito, we have here yung section 188. This section deals specifically with the reprographic reproduction by libraries, okay? So both public and private libraries, as long as non-profit, take note. So non-profit libraries may make a limited number of copies of a work even without authorization from the author or copyright owner, and only as may be necessary for them to fulfill their mandate. So take note, merong ganung proviso na dapat yung paggawa ng copies ng isang library ay only necessary for them to fulfill their mandate, di ba? Wag sosobra. So in the following cases, allowed ang library na gumawa ng limited number of copies. First, when the work is fragile or rare, di ba? If a work is exceedingly rare, di ba? Na kumbaga kailangan gawan siya ng copies for preservation in order to preserve the original work, di ba? Kasi kung isipin nyo, kung a work that is fragile, madalas hinihiram ng mga library patrons, di ba? Maaring mag-deteriorate yung kanyang condition, di ba? So in order to preserve a work that is fragile or rare, the library may make limited number of copies para yung copies na lang ang papahiram sa public, di ba? Next, when the work is an isolated article from a compilation of or brief excerpts of another work as requested by a person for research or study. So in this case, so kunyari merong researcher, pwede nilang payagan ito na to make copies. For example, kailangan niya ng copy ng isang article from a journal, di ba? So instead of photocopying the whole journal, yung yung isolated article lang na kailangan niya. Then, the library is also allowed to make copies if the purpose is to preserve or to replace a lost, destroyed, or unusable work in its or another library's permanent collection, di ba? So kung meron kang isang copy ng libro na nasira na or hindi na siya magamit dahil, for example, talagang nag-deteriorate na or luray-luray na, di ba? Hiwa-hiwalay na yung pages, yung spine. So in that scenario, the library is allowed to make copies of that work to replace the original that has been destroyed, di ba? Or unusable na siya or kung nawala. Next, the library is also allowed to have to make copies para magkaroon sila ng in their collection a necessary copy of a work that is out of stock, di ba? So for example, merong isang volume na out of stock na kay publishers, di ba? So humihingi sila ng copy sa publisher, sinabi na out of print na yan, di ba? So in that case, pwede siyang manghiram, let's say from another library, nung kanyang work na yon na out of stock na or out of print na, and make copies for its own collection, di ba? So that's allowed by law even if without permission from the author. However, what is not allowed, take note, is producing a volume of a work published in several volumes or the missing tomes or pages of magazines or similar works unless out of stock. Diba? So, in this case, pwede lang siya pag talagang out of stock na or out of print na yung volume na kailangan mo. So, in that case, pwede kang gumawa ng copies ng volume na yon or ng yung mga missing pages, di ba? Okay, so now that we have discussed kung ano yung mga specific provisions under our IP code relating to both statutory and general fair use, it's time now to discuss yung tinatawag na 4 fair use factors. Diba? These are the factors that we have to make our own determination or our own evaluation, our own analysis before we proceed in using a work without permission. Okay? And medyo nakakalito lang siya sa umpisa kasi nga, 'di ba, walang definite guidelines na pwede tayong i-consult or walang specific numbers na sinusunod tayo as to amount. However, after some practice, this will become second nature na lalo na pag 'di ba in your line of service as librarians, as educators, as keepers of information, sanayin nyo lang yung sarili nyo, and then after a while this will become second nature to you in such a way na you will be able to determine whether or not malakas ang chance na ang paggamit nyo ay fair use. Okay? So in determining whether the use made of a work in any particular case is fair use, the following factors shall be considered. First, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Okay? So, para saan ba ang paggagamitan nyo ng isang work? Diba? Bakit nyo siya kailangan gamitin? Yung purpose niya, pati yung character ng use. Diba? Are you going to use it for profit? Diba? Pagkakakitaan mo ba siya? Or is it non-profit ba? Educational ba siya? Because take note, a court of law will look very favorably on a use if it is for non-profit at saka it is for educational purposes. So, kumbaga, pag ganun, malakas ang laban nyo na fair use yung ginagawa nyo. Second factor is nature of the copyrighted work, diba? Ano ba ang nature ng work na ginamit nyo, diba? Is it fictional? Is it factual? Because, being a creative work, mas entitled to copyright protection ang isang work if it is fictional. Kasi nga, fiction requires creativity, di ba? As opposed to it's more of factual, di ba? Di ba? Kasi remember, the underlying facts, they are not protected by copyright law, di ba? So, in this case, the court will look into whether or not more on fictional ba or more on factual ba yung ginagamit ng work, di ba? As well as other considerations. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole, di ba? So, gaano ba kadami yung gagamitin mo, di ba? For example, a book, gaano makadami yung kailangan mong i-photocopy, di ba? Gaano makakapal, ilang pages ba yung kailangan mong i-photocopy. Again, there are no hard and fast rules. Wala tayong sinusunod na fixed number dito. Diba? It's decided on a case-to-case basis. Maaring a court will rule in one case na, in a book of 100 pages, photocopying 60 pages is infringement na. Pero maaari din naman in another case, sabihin niya na, yung photocopy ng whole book, it can be fair use under certain very limited instances, diba? So, ano siya? Again, case-to-case basis. And the last fair use factor here is yung effect upon the potential market value. Diba? So, yung bang paggamit mo ay ginamit mo siya in such a way na wala namang effect dun sa potential na earnings or kita ng author, or ginamit mo siya in such a way na parang medyo nalugi yung author kasi nga malaki yung potential earnings na wala sa kanya, diba? So, again, case-to-case basis determination yan. And of course, these 4 fair use factors are decided as a whole, diba? Maaring in one case, one factor is more important than the other, pero hindi natin pwedeng sabihin na, in all the time, ang pinaka-importante dyan ay yung effect upon the market value, or pinaka-importante dyan ay yung amount, diba? Again, it's a case-to-case determination. Okay, so pasadahan natin isa-isa yung 4 fair use factors na yon. First, the purpose and character of the use. In this case, merong tinatawag na yung transformative factor. Yung bang paggamit mo ng bagay or ng copyrighted work ay you used it to help create something new? Or is it merely copying verbatim from another work, diba? Kasi yung paggamit mo ng work into something new, it makes the use transformative. Yan yung term na ginagamit ng korte. So, yung paggamit mo ng transformative na yon, it is in favor of fair use. Kasi nga, you are repurposing or recontextualizing the use, diba? Ibig sabihin, hindi siya yung original use na in-intend ng author. So, for example, yung paggamit ng quotations from a book, diba? yung quotations na or yung excerpts na ililift mo from a book on its own, 'di ba? Hindi naman siya talaga yun ang Kumbaga, if you take it out of the context of the whole book, hindi na yun ang intended purpose ng author na, 'di ba? Kasi nga an excerpt is supposed to make sense only within the context of the whole book. Pero if you only quote excerpts or if you only quote small portions, that in effect is tantamount to recontextualizing it. Diba? Kasi nga, tinanggal mo siya from the original intent ng author. So in that case, it increases the chance na yung use mo ay transformative and therefore malakas ang laban mo na na fair use. Diba? So in this case, ang guide questions nyo dito ay yung mga material na kinuha nyo, from the original work has been transformed by adding new expression or meaning, okay? And second, was value added to the original by creating new information or aesthetics or insights or understandings, diba? So another example dito para lang ma-visualize natin. Yung sa music, meron dito tinatawag na yung sampling, diba? When you sample parts of one song into your own song, di ba? So for example, ako, musician ako, I will sample yung drum beats from another song, di ba? So yung yung drum rhythm lang, yung pinaka-beat niya. I will use 10-second sample from another song, i-incorporate ko sa sa kanta ko, di ba? So that's an example of repurposing, di ba? Kasi nga you used it for a different purpose. So yung mga ganyan, marami tayong jurisprudence lalo na in the US wherein the court has held in favor of fair use yung mga ganyan, yung mga sampling of short excerpts from other songs, diba? Next factor, the nature of the copyrighted work. Okay? Ang kailangan nilang tandaan dito ay generally, courts give more leeway to copying from factual rather than fictional works because the dissemination of facts or information benefits the general public. Okay? So, tulad ng sinabi ko kanina, mas paborot ang korte if ang ginagamit mong work ay more factual kaysa sa fictional. Kasi nga, a fictional work entails more creativity. And more creativity means a thicker copyright protection. Next dito ay fair use is more likely if you copy from a published rather than an unpublished work. Since we have to remember, an author has the right to control the first public appearance ng kanyang work, diba? So mas malakas ang laban mo na fair use ang iyong paggamit if ang pinagkuhanan mo ay published na, diba? Rather than unpublished siya. Kasi nga, kung unpublished siya, tas nagkuha ka agad ng excerpt dito, halimbawa, lugi naman si author, diba? Hindi pa nga niya pinapublish yung gawa niya in full, nauna ka pa na maglabas ng excerpt or ng quotes dito, diba? So, make sure na hanggat maaari, published work na yung pinagkukuhanan nyo. Next here, the amount and substantiality of the portion used, diba? So, the general rule dito, the less that you copy, the more likely it will be considered fair use, diba? Mas maliit ang kunin mo or ang kopyahin mo or ang i-reproduce mo, mas malaki ang tsansa na na fair use, okay? That's the general rule. Exception dito ay in cases of yung pagkuha ng heart or ng essence ng gawa. So even if you copy only a small portion, most likely hindi siya fair use if that portion that you took or that you copied is deemed as the pinaka-essence or pinaka-heart ng gawa, di ba? And then, to complicate matters, there's an exception to the exception in cases of parody, di ba? Kasi, familiar naman tayo, di ba? In parody cases, meron yung parodist, meron siya pinapatamaan, di ba? So, in parody, the parodist is permitted to borrow even the heart of the work in order to conjure up the original work. Kasi nga, yun yung pinapatamaan niya, di ba? So, kumbaga, if for example, an author will write something that is a parody of an existing work, allowed siya na gamitin even if yung pinaka essence ng work na yun. Kasi nga, in order to make the audience understand na pinapatamaan niya to, di ba? Kasi ang danger dito, what if hindi magets ng audience kung ano yung pinapatamaan niya, di ba? Edi useless yung kanyang parody, di ba? So, in cases of parody, okay lang na gamitin yung pinaka-essence ng work. Kasi nga, yun yung pinapatamaan mo. And fourth, we have here yung effect of the use upon the potential market value, di ba? Potential market or potential value ng work, di ba? So the consideration here is whether or not your use deprives the copyright owner of income or it undermines a new or potential market for the copyright work, di ba? So merong example dito para lang at least ma-visualize natin. It's an actual case sa US. Yung search engine, okay? Merong search engine, nagka-create siya ng thumbnails, di ba? Yung mga maliliit na images para ilagay sa website niya. So sabi nung copyright owners nung original images, hindi ka nagpaalam sa amin before mo ginawa yung mga thumbnails na yan. So therefore, you should be liable for infringement. However, sabi ng korte, no, there is no infringement because yung pag-create ng thumbnails na yun ay fair use. Why? Because it did not undermine the potential market for the sale or licensing of those images because the thumbnails were much smaller and of much poorer quality than the original photos and served only to index the images and help the public access them. So in short, wala namang effect upon the potential market nung original photos kasi nga, dahil thumbnails lang siya, sobrang liit niyan, di ba? Sobrang, yung quality niya, yung photo quality, sobrang poor as compared to the original na high-res na photos na hindi mo naman siya pwedeng i-print ng malaki. para ibenta as copies, diba? So, it's considered fair use, diba? Yung pag-create ng thumbnails na yon. Okay, so now we'll go to a sample fair use analysis. I'll give one scenario and then i-analyze natin para lang at least makita natin how do we apply the 4 fair use factors, okay? So in this sample scenario, the librarian of a private elementary school will conduct a read-along session. Okay? Read-along. Magbabasa siya, tapos sasabayan ng mga bata. Of a popular children's fictional picture book para sa English class ng grade 2 students. Okay? So to aid the students in reading along with her, she plans on digitally scanning the book's pages in order to create a PowerPoint presentation that will be shown to the class. Diba? So, para makasabay yung mga bata. Diba? So, ang balak niya, iscan niya yung mga pages nung book, tapos i-display niya sa PowerPoint para at least habang nagbabasa siya out loud, yung mga bata nababasa yung pages sa book, sa PowerPoint. Okay? So, this involves making of copies. Diba? Kasi nga, i-scan niya eh. And we have to remember, yung pag-create ng copies ay one of the exclusive rights ng author, diba? So, if we apply the general rule, dapat kailangan niya muna magpaalam kay author, diba? Bago siya makapag-create ng copies. But in this case, let's analyze kung maaari ba siyang maging fair use. So, pwede ba niya itong gawin even without prior permission from the author? So, in applying the 4 fair use factors, we apply yung first factor, di ba? Ano ba ang purpose kung bakit niya kailangan mag-create ng copies, di ba? If we look at the scenario, makikita natin that the use is non-profit, okay? It's educational, it's very clear naman na educational purpose siya, and socially beneficial. So, knowing na ganon yung analysis natin sa purpose, that is a plus in favor of fair use. Okay? So, makita natin plus FU, meaning plus fair use. Of course, ano natin to personal determination natin. But this will help us to conduct the work even if, I mean, wag natin antayin na korte pa magsabi na fair use yan, diba? So, in our personal analysis, as far as the purpose is concerned, pabor siya sa fair use, diba? Kasi nga, educational, non-profit, socially beneficial. Next, we go to the nature of the work used. Ano ba yung nature ng libro na kukopiyahin natin? Okay? It's a picture book, diba? Fictional picture book. So, the book is fictional and contains creative visual elements. Therefore, it deserves a thicker copyright protection. Kasi nga, like I told you kanina, mas pinoprotektahan ng copyright ang fictional works as opposed to works that are more based on facts, diba? Kasi nga, ang facts, hindi siya copyrightable. So in this case, not in favor of fair use kasi nga, yung book is fictional. Next, we go to the amount used. Okay? In this case, since read-along session, it's necessary na iscan niya yung buong libro. Kasi nga, the whole book contains the whole story. Kung babasahin niya yon at gusto niyang makasabay yung mga bata, kailangan niyang ipakita sa PowerPoint yung buong story, di ba? So, necessarily, kailangan niyang i-photocopy or kailangan niyang iscan yung buong libro. So, in this case, it's a tie-up, di ba? Kasi the fact that the whole book will be used, hindi siya favorable to our fair use case. However, since it can be justified dahil it is necessary to the purpose, di ba? Kasi isipin nyo naman, kung kalahati lang ng libro, halimbawa, ang photocopy niya, then how can the kids read along to the whole story, di ba? So, the fact of photocopying the whole book or the fact of scanning the whole book, it can be justified based on the necessity, di ba? it is necessary to achieve the purpose, diba? So in this case, ano siya, tie up. It's a toss-up between fair use and not fair use. And then, we go to the last fair use factor. Ano ba ang maaaring maging effect sa market for the original work? So in this case, we can make a determination that the sales of the book will not significantly suffer because of the scanning na gagawin niya. Bakit? Kasi isang scan lang naman gagawin niya, di ba? Even if it's a scanning of the whole work, it's only one scan. Babasahin lang niya to only one class of students, di ba? It's only one time, di ba? So she will not make multiple scans naman. So in this case, we can confidently say na this is in favor of fair use, diba? Kasi wala namang injurious or negative effect sa potential market ng original work. So if you add up all those, if you take it, yung ating analysis of the 4 factors as a whole, we can make our own determination na most likely fair use yon. Okay? So pag meron tayong ganung determination, we can now go ahead with the making of copies na kahit paano kampante ang loob natin na what I'm doing is not fair use. What I'm doing is not against the law. Diba? This is not infringement, diba? So kaya importante itong kaya importante na masanay tayo on applying the fair use factors on a case-to-case basis sa ginagawa natin trabaho. Kasi nga, I mean, di ba, really there are times na hindi practical na lagi pa tayo mag-aantay ng permission from the copyright owner to use a work, di ba? Kasi, of course, meron tayong mga timelines na hinahabol, may mga deadlines na hinahabol. The law recognizes that it is not always practical to seek permission first. That's why meron tayong fair use, di ba? And also, let us not forget, tayo bilang government employees, meron din tayong specific fair use exemption when the use is made by the national government, di ba? Or by educational institutions, halimbawa. So, yung combo na yon, it's actually very beneficial to us in the sense na we can more or less rest easy na if we make a judicious application of the fair use factors and we ensure that what we are doing is imbued with public interest, chances are very, very, very strong na fair use yan, di ba? So hindi tayo makakasuhan ng infringement, di ba? Okay, so we'll now proceed to a specific case. Pero ito sa US to eh.
Attorney?
Yes po.
Attorney Chuck, baka po pwede tayong mag-coffee break muna for 5 minutes before we continue with your presentation?
Sige. Can I just finish this Kasi after ng case na to, part 3 na tayo. So before we proceed to part 3. Okay. Thank you.
Po.
Sige, so ito lang, one case lang naman to, di ba? So Williams and Wilkins versus the US Court of Claims. In this case, si Williams and Wilkins, publisher ng medical journals and books, okay? At ang defendant dito, yung National Institutes of Health at saka yung National Library ng Medicine. So these are actually government institutions, di ba? These are government agencies. So ang ginagawa ng mga agencies na to, they would photocopy articles sa mga medical journals if they request ng kanilang mga researchers, di ba? So nung nalaman ng publisher na nag-photocopy ng mga researchers ng NIH at ng NLM, nagdemanda sila for infringement, di ba? Parang sabi nila, dapat hindi kayo gumagawa ng photocopies kasi sobrang dami niyan, parang lugi naman kami basically, parang ganun. Walang paalam eh. So they sued for copyright infringement at yung mga defendants naman, they raised fair use, di ba? So ang sabi ng court dito, yes, it is fair use because the copies were made for the researcher's own professional use and not for profit or other gain. And also the defendants placed strict limitations on photocopying, which kept the duplication within appropriate confines. Diba? Kasi in this case, merong internal policy yung library na a researcher can only make photocopies of, I think, parang a maximum of 50 pages at any one time. Basta parang ganun. Internal policy. So in that case, the publisher did not prove that it has been or would be harmed substantially by the practices of photocopying ng libraries na yon. And the court was also convinced that the holding defendants' practices to be copyright infringement would no doubt harm medicine and medical research, diba? So, in this case, sabi ng korte, on both sides, on the sides of the library and on the side of the requester or the user, scientific progress, untainted by any commercial gain from the reproduction, is the hallmark of the whole enterprise of duplication. So, in this case, sinabi ng korte na hindi infringement yung pag-photocopy ng researchers ng mga journal articles ng publisher. Okay, kasi nga fair use siya. Okay, so this is an actual ruling. So this can actually help us in kumbaga parang confidence booster na the court always more often than not looks favorably upon a fair use case, diba? So fair use tips, as much as possible, do not commercialize. You limit the reach, diba? Wag nyo gawing open to the public. You limit lang the people that have access. You make the use transformative. Use only the amount necessary to achieve your purpose. Again, don't forget to give proper attribution. And for government use, it must always be for the public interest, okay? So, just a reminder, nung start ng pandemic, nag-release yung sa US, yung nag-release ng public statement, yung library copyright specialist. Sinabi nila na it is evident that making materials available and accessible to students in this time of crisis will almost always be a fair use, diba? So let this be a reminder to us na as long as we stick to the educational purposes, as long as we stick to the public interest principle, much of what we do will be considered as fair use by a court if ever man na magkaroon ng kaso for infringement, okay? So yes, let's now have a short coffee break and health break before we proceed to part 3 of the lecture.
Ayan, thank you, Attorney Chuck. Ayan, pwede po tayong mag-coffee break. Ayan, yung mga kailangan pong magpunta ng restroom, pwede din po. Water break, ayan, pwede din po. And ulit, kapag may mga katanungan po kayo para hindi po ninyo makalimutan, pwede nyo na pong ilista sa ating Google Sheet para po mamaya ay babasahin na lang po natin, or pwede din pong i-raise nyo po kay attorney. Pwede po tayong mag-unmute later. Basta ang mahalaga po at least na isulat natin yung mga questions para hindi po natin makalimutan. And attorney, mukhang madami pong tanong.
Nakita ko na ngayon mga questions sa chat box. Sige, we'll try to address them later. Sige po.
Yan, sige po. It's 10:24. So balik po tayo at 10:31.
Mobile gaming is cool, but many games don't give a positive experience. Learning apps can be good, but even the best ones can be boring. What if we take the best of both worlds and make a learning app that's fun? Starbucks Whiz. It's not just a quiz app, it's an epic adventure. And your quest is to test the power of your mind. And choose from different subjects in science and math. Gameplay experience is seamless, and individual play is exciting and engaging. But the best part of Starbucks Whiz is playing with friends. Online multiplayer game modes challenge yourself and see where you rank against all your peers in this intense battle of wits. Starbucks Whiz is produced by the DOST-STII, so you can be confident that everything is factual and science-based. It's fun, educational, and best of all, it's free. Try Starbucks Whiz today.
In an attempt to contain the spread of COVID-19, schools were temporarily closed. Students now learn from home. Demand for online learning resources shoots up. The question is, how much can you trust your information source? Fret not, for Starbucks is now online. Starbucks, or the science and technology, academic and research-based, openly operated kiosks, is an offline site with full suite science and technology information resources. Today, Starbucks has been tailored fit for you. The wealth of knowledge contained in the country's first S&T offline digital library in a box, now accessible online. Accessing information in Starbucks Online is as easy as 1, 2, 3. 1. Go to the Starbucks Online portal via www.starbucks.ph. 2. Sign up by clicking the upper right portion of the main page. You will be directed to the login page. Click Sign Up here and key in your details. 3. Click Submit and you're on your way to enjoying Starbucks Online. Imagine a mountain of learning resources, and there is Starbucks, a beaming gold on the internet scene. Contains tons of STI information that are fun, legit, and easy to dig. From S&T news, to agriculture, to livelihood, and up to disaster preparedness. Say it! Starbucks has it! Try Starbucks Online and take advantage of this free, full suite, and fingertip-ready access to the brightest Starbucks yet. Visit Starbucks Online portal now and be at the forefront of science and technology information. Get to know Starbucks more. Like our Facebook page.
Ayan. So, are we back? Ayan. So, Attorney Chuck, ayan. Pwede na po ulit kayong mag-share screen.
Okay, thank you.
Thank you po.
Okay, we're now halfway through sa ating session for this morning. Part 3, ito yung mga na-compile ko na best practices for libraries. I hope that this part will be of special use to you guys. Based on the email na sinend sa akin ni Ma'am Nelly, yung mga certain concerns on library practices kayo, no? So again, I would like to start with this statement by the library copyright specialists sa the US, which they also released nung beginning of the pandemic. Sabi nila, they encourage the use of already licensed online content, openly licensed and public domain alternatives, and working with content vendors to find mutually agreed on ways to expand existing access to support social distancing and for instruction and research. So basically, what they are saying is, yes, there is copyright. We must respect copyright, pero wag natin kalimutan that there are also alternatives to using copyright works. Diba? We can use works that are in the public domain. Diba? As we all know, or as you may know, public domain works, ito yung mga works na nag-lapse na yung copyright protection nila. Diba? So meaning, they are free for everyone and anyone to use, even without permission, even without paying royalties. Diba? So merong public domain works that we can use. Merong mga openly licensed, diba? Yung mga open access, diba? Maraming klase yan. Meron tayong mga open access software, meron mga open educational resources, diba? Yung mga resources that are put out there by their creators explicitly to be used by anyone without permission. So, kumbaga parang they are, in a sense, they are dedicated to the public domain. Sinasabi na pwede nyo gamitin itong mga to ng walang paalam, diba? So, knowing that we have these alternatives will greatly help us in creating content, diba? In creating educational materials, diba? In creating content for online services without the fear na we might be committing copyright infringement. Okay? So first, sige, if you want to upload original content online, okay, so these are some tips that may be of use to you. So in this sense, original means you are uploading content that is wholly created by the library or by the agency or by the institution. It does not contain any copyrighted material belonging to another, di ba? So for example, meron kayong create na video, di ba? I remember kanina yung video na pinapakita nyo during the registration period, di ba? Yung mga ganon, di ba? So it appears na siya na talagang original video created by the agency, diba? It contains, diba, photos taken by agency personnel. It describes agency activities. Yung narration niya, it is created by by agency personnel. So in that case, it can be deemed as a wholly original work, diba? By the institution or by the agency, diba? So in that case, if you upload it online, take note that the copyright to the work, it can belong to the creator or to the library or to the academic institution if it is a private entity, or if it is a public or a government agency. Again, we apply the general rule na there is no copyright, diba? So, ganun lang. Let's be aware of that distinction. Of course, as it relates to us, bilang government employees tayo, if we upload work that we do according to our regularly prescribed official duties online, then we have to be aware na they are government works, and again, wala tayong copyright over it, di ba? Can others use our work without permission? it depends on the intended use, diba? Again, if the work uploaded is a government work, it can be used in most instances by anyone, even without our permission, except na lang for the instances that I mentioned kanina, diba? Like for example, kung gagamitin siya with the intent for commercialization or for profit, kailangan magpaalam from the agency, diba? And in certain instances, the library may be entitled to receive royalties, diba? So depending on the situation yan. Next, what if we are uploading content that contains copyrighted material belonging to another, diba? So in this case, we have to be guided first by the terms and conditions of the online platform kung saan natin siya ina-upload, diba? So normally, pinaka-common, diba? We upload videos to YouTube or we upload content to Facebook, diba? Uso na ngayon na diba? Yung mga government agencies, may mga kanya-kanyang official Facebook pages yan, diba? So we have to abide by the terms and conditions of the platform kung saan tayo nag-upload, diba? Kasi kanya-kanyang merong mga merong mga IP policy. Lalo na when it comes to copyright, diba? But one general provision that I've noticed na common sa lahat ng mga popular na online platforms ay they don't have a clause stating na automatically when you upload your content online to their platform, you are automatically transferring copyright to them, diba? So this is actually in order to parang kumbaga makabante yung ating mga users and yung mga creators na pag nag-upload kayo to Facebook halimbawa, it doesn't mean that you are waiving your copyright. It doesn't mean that you are transferring your copyright to them. You are still the owner of your copyright, diba? Provided that it is indeed copyrightable in the first place, diba? So, do you need permission to use the copyrighted material in your work? Of course, again, based on our prior discussion, depende yan, diba? Kasi maaring it can be under the general rule that permission is needed, or maari naman na permission is not required, especially if you use Creative Commons licensed material o yung mga tinatawag natin na CC licensed materials, or yung mga open educational resources na materials, diba? In that case, hindi na kailangan ng prior permission. And again, we have to be guided as always by the provisions on fair use, diba? Isipin natin lagi, is our use, can we rely on the fair use in order to do away with the securing of prior permission from the copyright owner? Okay? And then, next, when it comes to providing access to digital copies of library materials. Okay, kasi yung worldwide trend of digitization of library materials, it started naman way back even before the pandemic, diba? But there was a universal kumbaga uptick in the digitization of library materials, lalo na nung nagsimula yung pandemic no 2020, diba? Kasi nga all of a sudden everyone was forced to resort to distance learning, to working online, diba? So parang biglang all of a sudden nagkaroon ng awareness na parang we need to make, lalo na in the case of libraries, diba? We need to provide access to the public na hindi physically makapunta sa ating premises, diba? So how do we do that? We have to provide it online. And how do we make our inventory, our books available online, diba? The commonly accepted way is to digitize, diba? So to make digital copies, diba? So in making digital copies available, we have to ensure that online access is ideally it's limited, meaning so kung kunyari kung university library, limited lang siya for the faculty, for the enrolled students and only authorized persons, diba? and it can only be accessed maaaring magkaroon ng feature na the archive, the digital archive can only be accessed on site or for a limited period only, 'di ba? So maaaring, for example, kung ako estudyante sa isang university, I can only access the digital course materials for a certain semester, 'di ba? Halimbawa, ganun lang, 'di ba? So yung making sure that the access online is limited, it's actually a part of the, if maalala nyo, 'di ba, yung sa fair use factors, mas malaki ang chance na fair use siya kung limited access lang ang granted as opposed to making it available to the whole public. Diba? Making it available for everyone without na to classify such public access as fair use kasi nga maaring makaapekto sa market ng original work, di ba? Yung ganon. And also, we have to also be mindful to ensure that technological protection measures are in place to prevent any unauthorized use, copying, or distribution of the digital materials, di ba? So, lalo na ngayon, di ba? The existing technology makes it very easy to make digital copies, di ba? Minsan nga, right click lang, nakakagawa na tayo ng copy ng di ba? Nakasave na tayo ng copy ng photo taken from a website, di ba? So it's very easy to make copies, to make digital copies, di ba? So if you're a library and you want to ensure na na yung mga digital copies nyo ay hindi available for everyone to use, you must ensure that there are certain measures, security measures in place to prevent unauthorized copying and distribution. Okay? And here, of course, hindi natin may iwasan, there will be times na fair use is not applicable. Hence, there will be instances wherein you have no choice but to secure permission from the copyright owner. Diba? So in this case, ang technical term dito ay license, diba? The prior authorization that the copyright owner grants to a potential user para magamit yung kanyang work, ang tawag doon ay license, diba? So the author or the copyright owner licenses his work for the use of another person, diba? So in this case, the license is usually in written form, diba? And it must clearly state the names of the author and the potential user. Okay? The work sought to be used, the intended use or the right to be assigned, the duration of the use, and the royalties to be paid if applicable. Diba? So kailangan kumpleto yan. Nakasaad dyan sa license, sino ba ang author? Okay? Sino ba yung gagamit? Sino ba yung potential user? Ano ba yung work na gagamitin, 'di ba? And then para saan ba siya gagamitin, 'di ba? At ano yung mga rights ng copyright owner na i-allow niya na i-exercise ng author, 'di ba? So for example, pwede niya sabihin na, sige, for this particular work, I will grant you the license to reproduce, 'di ba? Or I will grant you the license to reproduce and to display publicly, meron ganun, 'di ba? So the copyright owner can assign either one or some or all of his rights to a user for a certain duration, di ba? So usually dapat naka-indicate dyan gaano ba katagal pinapahintulutan na gamitin yung work, di ba? Is it diba? Depende sa negotiation yun, di ba? And of course, yung royalties that are due to the copyright owner if they are applicable, di ba? And again, reminder, even if you are using public domain or Creative Commons licensed works or relying on fair use, it is still a good practice to always give proper attribution to the author, di ba? Para lang at least yung moral rights ng author ay nare-respeto natin. And then, just a little word about ebooks and e-journals dahil ito ay malaking part ng ng mga ng digitization process na very common ngayon sa mga libraries, we have to remember that the purchase of ebooks and e-journals include only access. They do not include copyright ownership, diba? So, magkaiba siya from purchasing a physical copy. Kasi, for example, ako, I buy a physical copy of a book, diba, from a bookstore. Pag-aari ko na yun diba, yung physical copy na yun. And after nun, I can lend it to anyone or I can give it to anyone kasi nga, I have absolute rights over it as the owner of that copy. That is not the same with ebooks and e-journals because even if nagkaroon ka ng digital copy sa sa laptop or sa hard drive or sa phone mo, nagkaroon ka ng digital copy ng ebook na yon, you are only being given access by the publisher. You can only, kasi for example, 'di ba, yung if you buy an ebook from Amazon, 'di ba? Sa Kindle nila, 'di ba? So you can only access yung Kindle book na 'yon sa Kindle program nila, 'di ba? So you are only what you are actually paying for is not ownership over the ebook. It's not ownership in the traditional sense, but rather you are only paying for access. So hindi mo pwedeng sabihin na ay pag-aari ko tong file na to and I can therefore make copies of this file, this ebook and distribute it to everyone. No, hindi siya ganoon, okay? Because unlike with physical books, meron kasi tinatawag na doctrine of first sale. Diba? Sa physical books, yun yung sinasabi ko kanina na once you buy a physical book, you are therefore the absolute owner of that copy and you can do with it whatever you please. Kasi nga, under the doctrine of first sale, the first sale of a copy of a work extinguishes the copyright owner's rights over that copy. Kasi nga, nagiging absolute owner na yung bumili. That is not the case with ebooks and e-journals and other e-materials. Kasi nga, what you're only paying for is access. You are not paying for ownership. Diba? Definitely not copyright ownership. So therefore, ang ebook, meron akong ebook na digital file sa aking cellphone, I cannot email it to my friends and say, "Uy, basahin niyo to kasi magandang book to." And then tapos i-email ko or I will send copies of the digital ebook to my friends. That's actually infringement because the most ebook licenses only allow the ebook to be used for personal purposes. They don't allow making copies. They don't allow distribution, diba? Why? Because distributing them would violate the author's right of reproduction since it would involve making digital copies. Diba? Kasi nga, since meron kang digital copy, kung gusto mo siyang ipahiram sa iba, you would make copies of that copy, diba? So parang you are actually reproducing the work. And that will violate the author's right of reproduction. Kasi nga, wala ka namang permission to reproduce or to make digital copies of the work, diba? So yan, that's one very important principle that we have to remember that distinguishes ebooks and e-journals from the regular physical books. Okay? We are not buying actual ownership. There is no actual ownership transferred to us. Rather, we are only paying for access. Therefore, most of the time, according to the licenses and terms of the ebooks, we are prohibited from making copies and distributing these copies to others. Okay? So ito, para lang makita natin, I put here isang sample ng ng ebook na terms of use. So yan, klaro naman diyan, 'di ba? Nakalagay diyan that sa letter D, the subscriber may not copy, download, print, scrape, store, publish, etc., distribute, broadcast, circulate, sell, or otherwise use the content or any portion thereof in any form or by any means, except na lang pag allowed siya, di ba? So there are certain cases na allowed yung yung paggawa ng kopya or pag-download or pag-distribute. But the general rule is di ba? It's prohibited, di ba? Kung makita niyo doon sa last line, the license code, di ba? Kasi nga since digital files siya, so meron siyang underlying license code. It's used only by the subscriber and the sharing thereof is strictly prohibited, di ba? Ito ay common ebook term of use. So therefore, ang advice natin dito is when you buy ebooks, always check the terms and conditions of their use, di ba? Kasi more often than not, meron siyang ganitong prohibition which prohibits the making of copies of that ebook or the dissemination or distribution unless na nga lang na otherwise prohibited. So siguro it would be a good practice if, for example, a library plans on purchasing ebooks for dissemination to its users, siguro mas maganda na they enter into negotiations with the ebook publisher at sabihin nila yung kanilang intent na to make it available to the public, halimbawa, or to their patrons, para they can negotiate a terms of use na hindi ganito kahigpit, diba? For example, they can negotiate na the publisher will allow them to disseminate, diba? Disseminate the e-materials to their patrons, or for example, if an agency wants to disseminate e-materials to their employees, diba? So for internal use lang, make sure that you are allowed to do so, diba? By the terms of use of the materials. If you are not allowed to do so, you can always negotiate with the publisher para at least klaro na na pinapayagan kayo. Kasi even if we have a provision on government fair use, even if strictly for educational siya, in reality, may mga publishers na they don't look kindly upon yung mass distribution ng kanilang materials. Even if sabihin mo na educational siya or even if sabihin mo na government use siya, pag talagang malawakan yung access and yung distribution, parang they feel na nababawasan yung kita ng kanilang mga authors. So it's always it's better to negotiate and to let them know of your intended use para at least kung payagan nila, edi walang diba? Walang kaso, walang problema. And then for the copyright naman with regard to journal articles, again, general rule dito ay the author of the article retains the copyright over it dahil siya ang sumulat dito. Exception is when the author expressly assigns or transfers his copyright to the journal publisher. We note here that under the IP code, section 180.3, nakalagay dito, the submission of a literary, photographic, or artistic work to a newspaper, magazine, or periodical for publication shall constitute only a license to make a single publication unless a greater right is expressly granted. Diba? So kung ikaw, nag-contribute ka ng article mo to a journal, unless there's an express clause in your contract or agreement stating that you are transferring your copyright to them, you as the author of that article still retain your copyright over it, and the journal only has a license to make a single publication unless na lang na meron kayong ibang usapan. Okay? And then also we have to distinguish, kung yung kanina binabanggit ko yung copyright over the journal article, this time yung copyright over the journal itself, diba? Again, a journal is a derivative work that is entitled to a separate copyright protection from the articles that are composing it, diba? So under the IP code, sinabi doon, diba, yung mga derivative works, they shall be protected as new works, diba? Provided, however, that such new work shall not affect the force of any subsisting copyright upon the original works employed or any part thereof. Diba? So, sabihin, a journal, since it is a compilation of articles, it can be entitled to a separate copyright protection as a compilation, di ba? Assuming na original yung pagkaka-arrange sa kanya, pero wala tong kinalaman sa copyright ng mga individual articles over na nakapaloob dito. Okay? So, guidelines for the use of e-materials. Again, we have to take note na hanggat maaari, let's try to use public domain or open access materials para nga hindi natin kailangan magpaalam, di ba? This makes our job so much easier if hindi natin kailangan magpaalam before gumamit ng e-materials. Number 2, always check the terms and conditions of the e-materials that you are using, di ba? To make sure that you are not violating the terms, di ba? Third is make a fair use analysis using the 4 factors plus the public interest consideration for government use, diba? So don't forget, when it comes to government use, dapat lagi merong public interest involved, okay? And then last, you should always provide adequate security or digital rights management measures to ensure compliance with the licensing terms of use, diba? So if the license prohibits the making of copies, if the license prohibits distribution, ensure that you have the adequate security measures para hindi yung public na humihiram or gumagamit ng e-materials, hindi sila nakakagawa ng unlicensed copies, diba? Okay, so quick pasada sa online copyright registration process na in-offer namin sa IPO before we end our lecture for this morning. As you may be aware of, so kami sa IPO, we are actually deputized by the National Library to receive copyrighted works for registration and deposit. Diba? Kasi under the IP code, the National Library is the main agency that can that is authorized to accept copyrighted works for deposit. Pero the IPO was deputized way back in 2011, I think, para nakakapag-issue rin kami ng aming sariling copyright certificate para do sa mga nag-a-apply para do sa mga nagre-rehistro ng kanilang work sa amin. Diba? So now with the pandemic still in place, we have started offering purely online copyright registration services, diba? So all you have to do is go to our website, www.ipophil.gov.ph. Under services, click nyo lang copyright and then click copyright registration and deposit. So makikita nyo, ayan, lalabas dyan yung copyright registration procedure. You just have to download the BCRR transaction form. So it's a form na parang meron siyang checklist and blanks that you have to fill out pertaining the details ng author, ng copyright owner, and ng work to be submitted. And then you email it to our bureau, copyright_registration@ipophil.gov.ph. And then after nun, pag na-receive na namin you also have to attach digital copies of the work that you are submitting, di ba? And then after nun, pag natanggap na namin, we will issue you an electronic statement of account. You have to pay a minimal fee. Parang I think the prevailing fee right now is less than 500 pesos. I'm not sure of the exact amount. Less than 500 for a single piece of work, di ba? So hindi naman siya ganun ka burdensome. And then pagkabayad nyo, that's the time when our staff will evaluate the work that you submitted to determine whether or not it is indeed among the copyrightable works in the IP code, diba? Kasi may mga times na pag hindi naman siya, may mga times na kuha kami ng submissions na yung pala ay hindi pala copyrightable. So in that case, we have to deny the registration. But assuming that your work is indeed among the classes of copyrightable works under the IP code, it will now pass evaluation, and thereafter you will receive an electronic certificate of copyright registration. Although of course, you can also request for a physical copy and we will send you one, diba? Para at least meron kayong meron kayong physical copy. Now, if you will remember, binanggit natin kanina nung umpisa, copyright is automatic from the moment of protection, diba? There's no need for prior registration. So, you may now ask, ano pang silbi ng pag-register namin dito sa IPO or sa National Library, diba? Ano ang benefits na makukuha namin when we register our works? First, kung nag-register kayo, diba? So meron na kayong e-certificate or physical copy ng Certificate of Copyright Registration, you now possess an official document, diba, issued by a government agency stating that you are the copyright owner of a certain work. So this certificate can be used as evidence in case of infringement or ownership dispute, diba? So kung sakasakaling magkaroon ng issue as to sino pa talaga ang owner ng copyright ng work na to, diba? Magkaroon ng kaso, at least meron kang evidence na pwedeng i-present which can be considered by the court in favor of you. Kasi nga, official document, diba? Issued by the IPO stating that you are the copyright owner of a certain work, diba? So that works in your favor insofar as proving that you are the copyright owner or the author of a work. And the second advantage of registration is it makes it easier for others who desire to use your work to identify and locate you so that they can obtain your permission. Kasi diba, kung merong third party na nagbabalak gamitin yung work nyo, pero for some reason, hindi niya ma-identify yung author, pwede siyang mag-consult sa aming database at kung nakarehistro yung work nyo doon at nakarehistro kayo as the copyright owner, then we can let the potential third party know, itong work na to, ang author niyan, sige niyan, ganyan, diba? So you can now seek permission from the author kung in case na gusto mong gamitin yung kanyang gawa, diba? So it makes it easier for the dissemination of your work, diba? And for potential users to identify you pag nakarehistro ka sa amin, diba? So those are the benefits of registration. But again, I just have to reiterate, registration is not mandatory, although it is highly, highly encouraged, but it is not mandatory for copyright protection. So ito yung sample na Certificate of Copyright Registration na ini-issue namin by our bureau, signed by our bureau director. So makikita nyo dyan, naka-indicate yung title ng work at kung sino ang author at yung creation date. Diba? Kasi the creation date is very important in order to determine yung period of protection niya. Diba? Kung kailan ba kisimula at kailan tatapos ang copyright protection na yan. Okay, so our key learning for our session this morning. First, copyright is not primarily for the benefit of the author, but primarily for the benefit of the public. Diba? So take note, tulad ng sinabi ko kanina, it's a balancing of interests, diba? The rights of the author and the right of the public. And let us not forget that copyright law serves the community by promoting the advancement of learning. We have a role in ensuring that copyright law is followed, but that responsibility should not lead to an over-compliance that limits the information rights of the people we serve. Instead, we should help our teachers and students use information to the broadest extent possible under the law. So, if there's one takeaway that I want you to have from our discussion this morning is that yes, it can be na when you view copyright law, parang it can seem a bit too restrictive. Maaring nakakatakot kasi baka isipin nyo na, baka mamaya makasuhan ako ng infringement. But wag tayong matakot sa copyright because let us remember, we have copyright alternatives. Meron diyang public domain, merong mga open resources, diba? Open licensed materials, and we have fair use. We have the fair use for the educational purposes, nandiyan yung fair use for personal research, nandiyan yung fair use for us as government, diba? Yung government use. So let us use them to our best advantage, diba? Let us not let our fear of copyright hinder us from performing our duties as public servants. Okay? So this ends my lecture for this morning. If you have further inquiries, mag-email lang po kayo sa amin sa IPOPhil Bureau of Copyright and Related Rights. Our email is copyright@ipophil.gov.ph. And then for registration of your works, send them to copyright_registration@ipophil.gov.ph. Also, yung bureau namin, meron kaming official Facebook page, the DCRR Facebook page, nandiyan yung link. So I hope you like and follow our Facebook page for updates regarding sa activities ng aming bureau. And also, if meron kayong mga gustong i-report na intellectual property violations involving counterfeiting and piracy, di ba? Yung pamimeke at saka pamimirata, pwede kayong mag-email sa aming Intellectual Property Rights Enforcement Office, operations@ipophil.gov.ph, or meron din silang sariling Facebook page, the IPOPhil IEO Facebook page. Pwede kayo actually mag-send ng message via Messenger. Pwede kayo mag-screenshot halimbawa ng mga accounts na tingin nyo ay nag-violate ng IP rights ng mga tao, di ba? So with that, again, thank you very much DOST for having me this morning, and I hope meron kayong mga napulot na mahalagang bagay sa aking lecture on copyright and fair use. So sige, maybe we can now proceed to the Q&A.
Yan, thank you so much, Attorney Chuck. And can we give Attorney Chuck a virtual clap? Ayan. And sabi po nila, at sabi ko din po, ang galing, ang ganda ng discussion, Attorney. At marami pong masasagot sa mga katanungan namin ngayong umaga. Ayan, so ready na tayo sa Q&A? Ayan. Okay, so Attorney, first question po. First question is, what are the guidelines or IRR on copyrights for mobile apps that has been developed? This is a question from... Ayun, tinanggal na pala nila.
Okay. Sige, okay lang. Okay, regarding mobile apps and I guess computer software in general, wala pa kaming specifically na issue na guidelines that covers copyright of mobile apps or software. But we have to be guided lang by the issuance on copyright registration and deposit. Later siguro I can email it to you, yung aming existing na IRR on copyright and deposit. Kasi nakalagay naman doon specifically that computer programs are among those works that can be subject of a copyright protection. So usually pag magre-register, assuming that a private entity or a natural person develops a mobile app halimbawa, so gusto niyang i-register yung copyright sa amin, all he or she has to submit is yung source code, diba? We require submission of the source code para at least yun ang i-deposit niya sa amin, because that the source code or the object code, that is what we consider as copyrightable under our law. So that is what is protected by copyright. Ngayon, there may be instances wherein certain functions of the mobile app or of the software can be protected by patent naman, di ba? So in that case, hindi na siya saklaw ng bureau namin, but instead sa Bureau of Patents naman ng IPOPhil, di ba? So hindi ko lang kabisado kung ano yung requisites for patentability ng isang computer program. For that siguro you will have to consult with our Bureau of Patents. But insofar as the underlying source code is concerned, that is without a doubt protected by copyright, diba? So kung kung meron man sa inyong balak mag-register sa amin, you have to give us, or you have to deposit copies of the source code. But again, take note, if you develop an app or a software pursuant to your official duties as a government employee, then chances are government work siya, and hence walang copyright over it, diba? So meron lang take note that meron tayong ganung nuance when it comes to government works.
Thank you, sir. And as a follow-up, can we also copyright the user interface design? Kasi po may creative aspect po siya of the mobile app, or just the source code?
Again, there may be times na yung user interface, by virtue of its of the creativity, diba? Yung graphical user interface, diba? The way that it is presented visually, it can be depending on the evaluation, it can be covered by copyright. Again, this pertains only to those works submitted to us by private persons, diba? Kasi nga, again, pag government employee, pag government work siya, it cannot be copyrightable. So let's not forget to stress that, kasi nga baka mamaya ang iniisip nyo is merong mga apps developed by DOST employees, diba? Siguro if that app was developed by a DOST employee pursuant to his or her regularly prescribed official duties, then chances are government work siya, and hence walang copyright over it.
Thank you, sir. And speaking of government publications, sir, may tanong si Picard, do we need to put a disclaimer in government publications for both printed in digital format related to copyright? Like for example, ilalagay po natin doon na disclaimer is, this publication can be reproduced in part or whole without written permission from the publisher or author. Although yung copyright po sabi nyo, it's not hindi po for copyright yung mga publications.
Ayan, actually, that's one thing na common concern, diba, whenever we lecture to government agencies. Kasi na-notice din namin na actually a lot of government agencies, yung mga publications nila, they put a copyright notice, diba? But more often than not, since government work yun, diba, dahil created nga by their employees, if we apply the law, kung tutuusin, wala siyang copyright eh. So we actually came up with a specific notice for government works that we have started, although we have not yet widely disseminated it to our fellow agencies. I believe parang DepEd yata at DTI napadala na namin ng I can send it to you afterwards. We have crafted a specific wording to replace the copyright notice for government publications. Kasi diba, normally ang makita mo dyan, diba, this work is protected by copyright, diba, blah blah blah. Ang wording namin is this work is a work of the government of the Republic of the Philippines. Hence, ganyan. And then merong proviso stating that it can be used by anyone except na lang pag for certain purposes na kailangan ng pahintulot ng ahensya, diba? So I'll send it to you para at least moving forward you can use it in your publications na government works.
Ayan, thank you so much, attorney. And for example naman po, since free po yung mga publications natin ng government, and for example yung publication na yun is ginamit or being sold online, can we sue for copyright infringement for that?
Ayun, so if in that case you mentioned that it's being sold online, diba? So it is being used commercially, diba? So for profit siya. So even if, well, you cannot sue for copyright infringement kasi nga wala namang copyright in the first place. But you can, as the agency that owns the work, you can actually go after the one or the user and assert your right as the owner of such work. Pwede siyang pagbawalan. You can tell them to cease and desist from selling your work online without permission, di ba? So pag sumunod siya sa'yo, then maybe afterwards you can enter into negotiations with them kung sakasakali man na gusto niyang talagang ipagpatuloy na gamitin yung inyong work for profit, then maybe you can be entitled to a certain reasonable fee, di ba? Na yung sinasabi ko kanina na it's akin to royalties, di ba? Maaring, depende na yun sa negotiation niya. But yes, to answer your question, definitely, if a government work is being sold for profit without the permission of the government agency, then si agency, meron siyang right para pagbawalan ito.
Ayan. So for example, sir, yung gumagamit after pagbawalan ng agency, can we seek for legal assistance?
Ano na yan? Kasi that will be considered a suit by the government. So, di ba? Baka dapat ang usap niyo diyan ay OSG, di ba? As the representative of the government. Pero kami sa IPO or sa Bureau of Copyright specifically, we can only offer guidance as to what the copyright law says, diba? Pero if you want to pursue legal action against a third-party user, you'll have to seek the services of the OSG.
Okay. Thank you, sir. How about, sir, kasi po nabanggit po ninyo that you will be providing us yung general statement para dun sa ating mga publications. What about naman po if we are going to draft a MOA with authors and co-publishers in relation to copyright of the material being published? May mare-recommend din po ba kayo na general statement for the MOA?
Actually, ano na siya? We can recommend a general statement, pero that would all boil down to yung negotiations nyo with the publisher or with the author. Kasi if, for example, you are negotiating for dissemination internally, edi baka sakaling pumayag yung publisher or yung authors na mag-disseminate siya internally, di ba? Meaning for for agency use lang, even without permission or without paying royalties, di ba? Pero it might be a different, feeling ko lang it might be a different issue when it comes to public dissemination, di ba? Kasi kung widespread public dissemination siya, my experience with publishers and authors ay pagdating sa ganyan, they would usually ask to be compensated, di ba? So depende yan sa negotiation. Of course, when negotiating for rights over a work, you have to be transparent, di ba? Saan niyo ba siya gagamitin, di ba? Kasi limited purpose lang ba or is it widespread para lang at least yung mga publishers aware din sila, kasi baka mamaya sabihin niyo na internal lang and then after all later on they might discover na available to the public. So in that case, magkakagulo pa di ba? So depende na sa negotiations niyo.
Ayan. Thank you, sir. And in relation to this, we have a follow-up question from Ma'am Rina of Picard. Ma'am Rina, go ahead. Please unmute yourself.
Yes. Good morning po, attorney.
Hi, good morning, ma'am.
Follow-up question lang po. Actually, ako po yung nag-raise ng issue nung regarding dun sa, kasi po sa amin po kasi sa Picard, meron po kasi meron pong mga books na may author po siya. Pero nagre-request po sa amin na i-publish siya. So, we enter into a memo of agreement na through po din yun, through SUC po siya. Pero ang lang po namin doon is, siyempre po, kami po yung nag-print, bibigyan po namin ng copy. Siya naman po nakalagay ng author. Pero bibigyan po namin siya ng copy. And then, in case lang po ba na gusto niyang i-reproduce, kasi siya yung author, di po ba? Tapos gusto niyang ibenta, pwede po ba yun, sir? Attorney?
In that scenario that you are describing, si author ay nabanggit nyo employee ng SUC
Yes po.
So, ano siya?
Pero parang retired na po siya eh.
Retired na, so private person na siya.
Opo, pero siguro ano po siya, ano po din niya, yung topic po kasi naman ng book niya is related doon sa job niya.
Ano naman, I'm sure na very very familiar tayo sa yung sa practice, 'di ba? Usually may mga may mga authors na magre-release ng libro upon retirement, 'di ba, from a particular agency, 'di ba? So, like for example, sa amin sa IPO, pag merong tao na wala na sa agency and then gusto niya magsulat ng ng libro about IP, 'di ba? Pwede naman niyang gawin 'yon. Now, as long as ginawa niya yung work na 'yon when he is separated from the service na, either by retirement or by resignation, so ginawa niya na 'yon as a private individual and hence meron na siyang copyright over it, 'di ba? So kung meron siyang copyright over it, okay? And then the publisher usually has only a license to publish the work, but the copyright to reproduce generally remains with the author, di ba? Unless na diba? So kung walang express transfer ng copyright sa publisher, if the copyright remains with the author who is a private individual, then siya pa rin ang may control ng copyright. And hence, kung gusto niya itong ibenta, karapatan niya 'yon, di ba? It's a different matter if the author is still a government employee employed within the institution or the agency. Kasi in that case, babalik na naman tayo sa principle na government work siya, maaari siya maging government work, di ba? Kasi lalo na if it pertains to yung expertise niya, di ba? In that case siguro it's not a matter for the IPO to decide, but siguro it's a matter for the court, di ba? Kasi the court can rule na yung book na nirelease niya based on his expertise while still a government employee, pwede siya maging personal kasi hindi naman siya part ng trabaho niya, or pwede siya maging parte. Depende sa appreciation ng court sa facts, di ba? So, siguro let's just be guided na lang by the sino pa talaga ang copyright owner. So, kung ang copyright owner ay si author pa rin at siya ay private person, karapatan niya ito ibenta. Kung government employee siya, then we apply the rules on government works.
Follow-up lang po ulit. Kasi po itong author na to, ni-register niya po yung book niyang yon, yung title ng book na yon sa National Library. Yun po bang registration po ng ganong mga work of art sa National Library, is it different from the IPO?
Ay, pareho lang po siya, ma'am. Kasi like I mentioned kanina, the IPO was only ano ba yung term ito? We were only deputized by the National Library to receive and issue copyright certificates on their behalf. So, under our existing arrangement ngayon, even if physically magkaiba ang itsura ng certificate na ini-issue namin versus sa ini-issue ng NLP, for all legal purposes, they are practically the same. So, one certificate from the NLP is the same as it's as if sa amin nag-apply din and vice versa. Diba? So walang pinagkaiba yon.
Sir, yun po bang pag-issue ng certificate na yun, ng registration na yun, kailangan po ba yun ilagay pa, sa printed publication or no need?
No need naman po. Saka again, the mere fact that a certificate of copyright registration was issued to an author, it does not necessarily mean na talagang may copyright siya. Kasi minsan, meron mga nakakalusot, di ba, sa evaluation na minsan government work siya, pero since hindi naman siya clear sa application, maaring the NLP might make a mistake of issuing a certificate even if government work siya. So in that case, it can be there can be a dispute as to copyright ownership that can arise from that, which is proper for the courts to decide, di ba? Kasi in a way, yung sa NLP tsaka yung sa amin, you can guess na it's semi-ministerial kasi even if we evaluate the works that are submitted to us sa IPO halimbawa, even if we evaluate them for registrability, we can only rely on kung ano man yung sinubmit na papeles, di ba? There are times na we seek certain clarifications pag mayroong malabo, pero we can only rely on so much. Di ba? We don't have the manpower or the resources to conduct a full-fledged investigation as to sino ba talaga ang author nito. Kailan ba ito ginawa, di ba? So, be aware lang tayo na gano'n. And yes, to answer your question, pareho lang naman yung certificates na ini-issue namin insofar as their legal effect are concerned.
Thank you po.
Ayan.
Thank you, ma'am.
Thank you, Ma'am Marina. Ayan. Attorney, follow-up po. Pagka po, we enter into MOA with a private person na sumulat ng ganito. So, government funding ang gagamitin. Mag-a-apply po ba sa kanya yung as government work yun or private work pa din siya?
Ayun, since you mentioned na government funding siya, this is the time na baka lang sakaling maging covered ng Technology Transfer Act. Although hindi ko na siya naisama sa lecture kanina kasi for due to time constraints. The TTA, diba, it covers instances wherein research works that are funded by the government, meron pa ring copyright si researcher, even if such researcher is a government employee, or definitely if a private person yan, definitely meron siyang copyright over it. However, by virtue of the TTA, the law requires a mandatory transfer of the copyright from the author to the institution or to the funding agency. Diba? So, if you want to learn more about the TTA, I can give you the email address of our DITTB Bureau. Yan yung bureau namin na one of their divisions ang nag-handle ng mga technology transfers. If you want to seek further clarification as to the types of research works that can be yung copyright that can be transferred to the funding agency, I will give you their contact email.
Ayan. Thank you so much, sir. Kasi I think we have common concern with other agencies here about the thesis and dissertations that are being being done by our DOST scholars. So may output po yung mga DOST scholars natin na thesis and dissertation, and nakalagay po siya dito sa aming library. Ngayon, ang question po sa amin, is it okay for us to digitize this government-funded thesis materials kahit po may nakalagay doon may mga other thesis po kasi na may nakalagay na this thesis can only be accessed after consultation with the author. May nakalagay po kasi na gano'n na note. So, pwede pa din po namin ba siya i-fall under fair use?
Ayan, the general rule, insofar as thesis at dissertations are concerned, yung copyright remains with the author or with the student, diba? Regardless of whether scholar siya or funded by an entity, the general rule is that the copyright remains with the author, diba? So yung pagdi-distribute or paggagawa ng copies, kailangan munang dumaan sa pahintulot niya unless talagang na fair use siya. However, like I said, it would depend kasi if yung thesis niya ay magiging considered na research na qualified under the TTA, then that means that there is a mandatory transfer of the copyright from the author to the agency or to the institution, di ba? Or maaari din naman na if the scholarship agreement meron dong express provision stating that there is a transfer of the copyright from the author to the agency, and the author willingly agree to such provision, meaning, di ba, normally pag may mga ganyan, pinipirmahan naman yan, di ba? So may consent. then in such a case, the transfer of the copyright or the assignment of the copyright from the student or from the author to the agency can be valid. Diba? But again, in the absence of any such express provision, the general rule will remain that the copyright belongs to the author.
So, sige sir, thank you po. We will be consulting with the TTI?
DITTD,
Technology.
sige.
Yes. Sige po. Ayan, next question po. Can we, with regards to fair use naman po, nabanggit din po kanina na with the onset of the pandemic, uso na yung online document delivery where we photocopy or we scan a part of a journal or an article and send it via email to our clients. So, is it allowed for us to digitize the whole document, or I mean material, or just the portion of the material?
Ayun, like I mentioned kanina, diba? So the final determination, korte lang makakapagsabi, diba? So I can only give you my unofficial, diba? Unofficial opinion on this. Like I said, be guided by the 4 factors of fair use, diba? So in that case, sa tingin nyo ba yung pag-photocopy ng whole material ay excusable under fair use? Ito ba ay nararapat para ma-achieve ng researcher or ng user yung kanyang purpose, di ba? Be guided na dapat hindi siya nakaka-apekto sa potential earnings ng author or ng copyright owner. And again, since you are a government institution, diba? So applicable sa inyo ang government fair use, meaning that any use by the government, as long as compatible with fair use and imbued with public interest, so maaari siyang maging fair use. So these are just the considerations that you have to apply, diba? As a whole pag sa mga ganyang scenarios, diba? So like I said din kanina, wag nating hayaan na yung takot natin na makasuhan ng infringement hinder us from fulfilling our mandate and doing our duties as a public servants.
Ayan, thank you sir. Kasi po, yan din yung parang laging takot na baka mademanda. Ayan. And still, attorney, in relation to fair use, okay lang po ba yung acknowledging or expressing thank you to the singer for using his song in the agency annual accomplishment report video presentation? Yan, okay na yun.
Diba, ang lagi kong ini-impress upon the audience, diba? Wag natin kalimutan yung moral rights ng authors, diba? Even if we are using it as allowed by fair use, so even if walang paalam, diba? As a courtesy lang, diba? Doon sa nag-create ng work, wag natin kalimutan to always acknowledge them, diba? Kasi let me tell you, a lot of the times na nagkakaroon ng issue, nagkakaroon ng kasuhan over copyright, it all boils down to the fact na hindi nakakredit si creator, diba? Because diba, understandable, diba? Kung ikaw ang lumikha ng isang bagay, you would always want na pag ginamit ito ng ibang tao, na makilala ka, diba? Kasi pinaghirapan mo yun diba? So it's actually parang very basic na dapat kung merong ibang gagamit ng gawa mo, diba? At the very least, kahit nga wala ka ng royalties na entitled dito, at the very least, sabihin na ikaw yung gumawa nun, di ba? Para malaman ng mga tao na ikaw ang creator, di ba? So it's a very good practice na ginagawa niyan, di ba? Para at least yung singer napapanatagalog niya na his or her talents are being recognized.
Ayan. Thank you, attorney. Kasi po, naalala ko yung si Sharon tsaka si ayan.
Parang nakita ko nga sa
malaman ni director.
Yeah, very very timely yung issue na yun. Pero when I was reading about the issue, 'di ba, sa mga articles, one thing that stood out to me, hindi naman si Sharon yung hindi naman si Sharon yung composer ng kanta, 'di ba?
Na lang umuwi.
She was the performer, 'di ba? But she was not the composer, she was not the author. So, one of the nuances ng copyright law natin ay meron kasing hiwalay na copyright ang composer ng isang kanta, and then yung performer na actually kumanta, there's this thing that you call a related right. It's not copyright per se kasi wala naman siyang kinikreate na original work, but the performer in singing the song, he or she helps the copyrighted work, the composition, reach a wider audience. So meron siyang, even if wala siyang copyright na per se, meron siyang related right over the performance of the song. So si Sharon, when she made that comment, she was making it as the performer of the song, diba? Kaya sabi niya parang, nakakaya na bakit kinanta sa ganyan. Pero actually, hindi naman siya ang composer diba? So, kaya nga if you will notice, diba, after a while, dinelete na lang niya yung post niya, tapos sabi na lang niya, good vibes na lang, diba? Kasi nga, siguro na-realize niya, hindi naman pala ako yung composer, diba? So, ayan, it's nevertheless, it's a good lesson to illustrate yung, yung importance of the moral rights of an author, diba? Na dapat lagi napoprotektahan ito. And not just the author or the composer, but also, yun nga, yung performers, kasi nga, they have related rights with regard to their actual performance of a song.
Ayan. Ayun, so naliwanagan na tayo tungkol doon. Thank you, Attorney. And due to time constraints, I will just be reading 3 more questions. And before that, Attorney, okay lang daw po ba na lahat po ng participants ngayon dito ay mabigyan po ng copy ng inyong presentation?
Yeah, walang problema. Or like I said, government work, diba? So, wala man akong copyright dyan, diba?
Ayan, okay.
No problem.
Thank you, Attorney. So, lahat pala, yung mga ginagawa namin, for example, na-i-invite kami for a webinar, lahat ng mga na-related sa job namin, lahat ng presentations namin are free of copyright.
Yes, kasi siya, diba?
Government owned.
ginawa niyo siya as part ng trabaho niyo, diba? So, under the law, it's a government work.
Okay, thank you po. Ayan, so, ito, sir, does the Philippine copyright law covers those research articles authored by foreign authors or produced in other countries?
Ayan, when it comes to foreign works and foreign authors, naman diyan, ang mag-a-apply ay yung ating treaty obligations, diba? Kasi meron tayong tinatawag na the Berne Convention. It is an old treaty, parang ito yung tinatawag na the mother treaty of all copyright laws ng mga bansa. So it provides na even if a work by a foreign author is not registered with us here in the Philippines, nevertheless, we are obliged to extend the same protection to the work. It's as if it's as if the work was also registered here and was created here, diba? So parang, kumbaga, it allows a work that is made outside the Philippines to be entitled to the same copyright protection as a work that is locally created, diba? So merong reciprocal protection of rights, diba? So meron pa ring protection ang mga foreign works that are being used here in the Philippines.
Thank you, sir. Sir, next question. If we are going to compile a biobibliographies of experts and scientists, do we need to ask permission from each of these experts before we publish online? For example, nakuha namin yung data nila from open access sites and from Google Scholar. Are they going to fall under the derivative works?
Pwede, diba? As long as yung pagka-compile nyo ay original dahil by reason of the selection or the arrangement of the materials. As far as yung pagkuha nyo ng data, maybe that is more concerned with the data privacy laws. Although, like you said, if available naman yung data in open access websites, baka that fact might be sufficient to dispense with the need for for prior permission. But again, in my experience, pagdating sa mga ganyang bagay, it's always a good practice to nevertheless inform them, di ba, na we are planning to make a compilation of ganyan-ganyan to be released publicly, di ba? So para lang at least aware yung mga tao na yung mga data na yan lalabas doon, di ba? That they are included in such work, di ba? Either from the person themselves or from the estate kung patay na yung tao. And then again, as always, be guided by the rules of government works, di ba? With regard to the publication na yun. So maaring government work, so maaring walang copyright.
Thank you so much, Attorney. And for our concerns, kasi marami pa pong may concern ng thesis and dissertations and government-funded publications na gawa or contract from a private. So mag-a-ask tayo ng advice from the Technology Transfer Office. Ayan.
Yes,
so far,
Ma'am Nelly, email ko na lang sa inyo yung contact email ng aming DITTV.
Sige po, Attorney. Thank you po.
Sige, thank you.
Ayan, thank you so much. At wala na po akong nakikitang question dito na hindi nasagot. May gusto po bang mag-raise ng question? Isa lang. Ayan, mukhang wala po. And for the information of everyone, Attorney Chuck will be our consultant in crafting our policy also with the ScINet. So kung ano man po yung mga hindi masasagot ni attorney ngayon at hindi natin maitanong ngayon, ay itatanong na lang po natin kay attorney as we go along with our activities within the year. Ayan, once again, attorney, thank you so much. Thank you for your time. And now, I would like to request once again, Ma'am Linderlit M. Maglake, to give or to read the citation of our Certificate of Appreciation to Attorney.
Yan. So again, thank you very much po, Attorney Chuck. Napakarami naming natutunan ngayong araw. And sabi nga po ni Irene, kayo pa rin po kasi magiging consultant namin. Madadagdagan pa po yung mga tanong namin in the future. Ayan. So in behalf po of the Department of Science and Technology, Science and Technology Information Institute, and the ScINet, DOST-STII Philippines, we would like to award the Certificate of Appreciation to Attorney Ezekiel D.G. Valerio for serving as our resource speaker and guiding the discussions for the webinar on capacity building for DOST-STII PWG on copyright and intellectual property law, hosted by DOST-STII and held on March 16 today via Zoom. So this was signed by our Director Richard P. Burgos, the Executive Committee Chair of DOST-STII-PHIL. Maraming salamat po, sir.
Thank you everyone. Thank you DOST and thank you Director Burgos and Ma'am Nelly for the invitation to serve as your resource speaker for this and also for serving as your consultant para sa inyong crafting ng library policy. Maraming salamat po.
Ayan, thank you po muli. And now, may I request everyone to open their camera. Ayan, magkakaroon po tayo ng photo op with our speaker. Ayan, pabukas po ng ating mga camera. And ayan, lahat po ng mga nakabukas ang camera, for your information, disclaimer po, ilalabas po natin ito at ang mga mukha ninyo sa ating posting sa Facebook. Ayan. So, sa mga hindi pa po nakakapagbukas, ayan, kung hindi po kayo amenable na mailagay sa Facebook or ma-post online ang inyong mga mukha, okay lang po na mag-off ng cam. Okay. And ayan, meron po tayong dalawang frame. Ayan, meron po tayong dalawang frame. So, stay smiling na lang po while our tech do a screenshot. Ayan. Saglit lang po. Ayan, sige po. We will wait for 1 minute para sa mga hindi pa po nakapag-open ng cam.
Irene, baka kasi may mga computers dyan that do not have provisions for webcams. Kaya talagang kahit anong pilit nila, hindi nila ma-open yung camera nila.
Okay. Ayan. Okay. Ayan. Nadadagdagan po yung mga nagbubukas. Okay. Sige po. We will be taking a screenshot. Ayan. Ang ating pong tech team ang kuha ng screenshot. Ang tech team po natin ngayon, actually pala ay kami-kami din. So kami po ay humihingi ng apology sapagkat na-late po tayo kanina because we were trying to look into kung paano yung gagawin namin dahil very in demand po yung aming tech team. At kami na po yung naging tech team din po. Ayan, once again, thank you so much. Sige po, I think may kumukuha na ng Ayan. Okay. I-check ko lang po. Ayan, smile lang po kayo dahil hindi po natin alam kung saang frame po kayo. Okay. Okay, thank you so much. Ayan, nakunan na daw lahat. So, thank you so much for your time. And finally, let's hear a closing remarks from the Division Chief of the Information Resources and Analysis Division, Sir Alan C. Taule. Sir Alan?
Thank you, Irene. And it's 10 minutes before noontime, so I think it's still proper for me to greet you. Good morning. And I'm sure that many of us have profited immensely from the lecture presentation by our very esteemed main speaker, si Attorney Chuck de Guzman of IPO Philippines. So maraming salamat po, Attorney, for giving us a very comprehensive backgrounder on the topic of capacity building for DOST-STII Philippines TWG on copyright and intellectual property law. Actually, kanina, gusto ko na sanang magtaas ng kamay tungkol dun sa Tech Transfer Act. Kasi po, hindi naman sa nagyayabang, pero kasama po ako dun sa original TWG. May mga kasama ako from Picard, sa PCHRD, and TAPI, and also, of course, ITDI and NAST, na talagang literally naglamay dito sa pagbalansa ng TWG. Mostly talagang coordinating work yung ginawa namin because much of the work has already been done bicamerally from committees in both the House of Representatives and the Senate. So it's just a matter of marrying the two versions into a final version that is acceptable to all concerned. But anyway, siguro sa ibang lecture na lang yung Tech Transfer Act. We hope that we'll be able to secure the services of Attorney Chuck once again kung sakaling kailanganin natin ng backgrounder dito sa sa Tech Transfer Act, or naalala ko pa nga RA 150 ito, kung ako nagkakamali. But anyway, thank you so much, Attorney Chuck, and also I'd like to express our thanks to the members of the DOST-STII Philippines who all took the effort to participate and attend this workshop. Kailangan po kasi natin ito because, the webinar was successful in providing greater awareness and appreciation among DOST-STII members in identifying and addressing issues of copyright and other related intellectual property issues. And another good thing about our research speaker is that he also advised us about copyright exceptions and exemptions, including the concept of fair use, or the right to use a copyrighted work under certain conditions without permission of the copyright author. No? So as explained by Attorney Valerio, it helps us from being trapped into a rigid application of copyright law that would stifle the very creativity the law is designed to foster. So minsan, hindi rin maganda na masyado tayong maging legalistic sa mga bagay because it might actually produce the opposite result of, stifling or hindering the flow of creativity. So I think it is important for us to develop an understanding and appreciation for copyright law. As librarians, we are entrusted by content creators to protect their interests, a relationship that the LIS professionals are duty-bound to uphold. And I'm thankful that through this webinar, we should become more proactive in ensuring that creators receive appropriate rights for their own ideas and creativity, and to promote artistic creativity by protecting the creator while allowing others to gain access to it legally. So my hope is for this webinar, that this webinar shall be invaluable in our noble effort to develop one unified institutional policy on library services that shall be applied for all DOST library and information centers. In the end, may we be guided in coming up with effective strategies for DOST libraries under ScINet Philippines to become more responsive to the needs of library clients for STI information. And may we be guided from here on to determine policies and guidelines in crafting a library policy manual. That is our common hope among members of the ScINet. And with that, I'd like to thank you all for attending our workshop, and many thanks to our the STII ARAD staff who made this activity possible, and the contributions of our ScINet members who also made it possible for this activity. Many thanks, and may we all have a good lunch. Thank you, everyone.
Thank you, Sir Alan. Ayan, virtual clap po para kay Sir Alan. Ayan. And I would just like to repeat po yung key learning kanina na iniwan sa atin ni Attorney Chuck. Sabi po niya, copyright law serves the community by promoting the advancement of learning. We have a role in ensuring that copyright law is followed, but that responsibility should not lead to an overcompliance that limits the information rights of the people we serve. Instead, we should help our teachers, our students, even our researchers use information to the broadest extent possible under the law. So dapat under the law pa rin tayo lagi. Ayan, once again, thank you so much everyone. We hope that everybody learned something from today's webinar. And finally, shared on the screen is our evaluation link. So kindly fill this out. We will be providing an certificate of participation to all participants who successfully registered and submitted their accomplished evaluation form. The certificate of participation will be sent to the email address that you have provided in the evaluation form on or before the 23rd of March 2021, and along with the recording of this webinar. Recording plus the PowerPoint presentation. So thank you so much everyone for participating, and we hope to see you in our next webinar. So stay safe everyone, and stay connected with us. Once again, thank you, Attorney Chuck. And the link also of our evaluation form is posted in the chat box or in the chat room. Ayan. Pwede nyo pong i-click lang yon. And if you are done accomplishing our evaluation link, you may leave the room. Once again, thank you so much, everyone. Stay safe, stay healthy, and God bless.
Thank you everyone. Ingat po.